reach you, David.
So I'm going to slide it on, like, in a bar. Right. Which bit?
It's just on the end.
Oh, yeah, yeah. Oh, I have read
Oh,
this.
sorry.
I have read this much as right.
Why did you put that on where?
No, she put them.
But like yesterday, you did.
Oh, hang on. Is it all the same?
Oh.
I never have.
One is plant and
One
one is
McGregor.
Oh, okay. Right.
Actually, one minute. Right, is our court ready?
Court rise. I've seen an application in the matter of Rees and others and the Commissioner of Police of Metropolis.
Yes.
Lord and Lady, I appear for the appellant in this matter, and the known friend Mr. Beer QC, Miss Ventham, appear for the respondent, Commissioner, Metropolitan Police.
Right.
Lord, can I just check before we go through and just sort of do a little bit of housekeeping in terms of the bundles? Obviously, today is listed for my client's substantive appeal, and of course, there is also the matter of the application for permission in the cross appeal. I wondered if your lordships had any views as to how you would wish us to proceed in terms of dealing with.
Well, are you? We'll obviously deal with the application for creditors, but are you opposing it on the grounds that you're unduly prejudiced or anything like that?
No.
No. Right. So in that case, would you please develop your appeal, and then we'll hear Mr. Beer both in response to your appeal and on his application to cross appeal.
Absolutely. That's.
But
great.
you're not now claiming any.
No. You'll have noted from our skeleton there is a separate issue in terms of the other.
Absolutely.
Yeah, but that's a separate issue. We certainly know. You've seen my skeleton argument. We've addressed it fully.
That's very fair, Mr. Newman. Thank you very much indeed.
Yeah, grateful. So just in terms of housekeeping then.
I'm afraid the muddle, I'm sorry to say, in part was down to the court office not referring the appeal on to someone like myself to consider the matter. So anyway, there it is.
It's always unfortunate when it's the court's fault rather than your opponent's fault. But
yes. Well,
on to housekeeping then.
Most people think it's the judge's fault anyway. Right. Now.
So we have relatively slim court appeal bundle with the relevant documents, and I thank learned friends for correcting. I think there are a few corrections. Hopefully they've made your way into your bundles. And then there is an authorities bundle, which certainly my version extends to 2 lever arch files with some 36 tabs.
Yeah, I'm not going to refer to anything like all of them, are we?
No, of course not. And unfortunately, the reason it's so big is because we were referring to lots of quantum appeals, and you've seen the various tables. I suppose it would have been remiss not to have included the case, just in case, for some reason or other, the court wanted to have a look at them. But yes, no, it's absolutely right. We won't be referring to all of those. Finally, last night...
It's like when someone puts Donahue and Stevenson in the bundle of authorities, isn't it? Yeah. All right.
Well, yeah. Well, I mean, hopefully we're not sort of arguing in such trite areas a little bit, but we'll see what we get to. Finally, and this is my fault, I had an IT issue at home yesterday. There were 3 additions to the authorities bundle. none of which I think was emailed through to your clerks last night. Two of the three things were already referred to in the papers. One is just the Senior Courts Act 1981, Section 35A, the interest provision.
Which tab are they now?
So, well, I'm not sure if they've been inserted. I have hard copies, so they should appear at 1A, 12A, and 29A. If they've not, I've got tabs and...
Well, someone has inserted Section 35A, Supreme Court's Act.
Yeah.
I think my clerk has done it. And then 12, what was it?
12A is Rowland's.
Yes, that's all been inserted.
Was a case on interest, which is at 29A, Carrasco and Johnson.
Yeah.
Yeah, okay, I'm grateful for that.
Right, let's crack on, shall we?
Certainly. Well, my lord, there are two grounds of appeal on behalf of the appellant. The first relates to the substantive award for loss of liberty, and particularly the approach taken to the immigration detention cases by the judge at first instance.
Yeah.
And the second ground relates to interest. I'll deal with them in turn. It is the appellant's case that the judge erred in principle in awarding the £60,000 in damages for loss of liberty. That award, that loss of liberty, related to, and I can take you to this in the judgment if needed, but just as sort of headlines, there were 682 days in prison. That's paragraph 23. 682
yes.
days in prison.
Yeah.
That's paragraph 23 of the judgment, of which 5 months of that was in category A conditions, the restrictive conditions of detention. That's paragraph 25 of the judgment. And then the appellant was on restrictive bail conditions for a further 1 year, 8 days. That's between his release from detention on the 3rd of March 2010 to the 11th of March 2011, when no evidence was offered in relation to the criminal proceedings. And again, you can see a reference to that, paragraph 23 of the judgment.
For a further year and what, sorry?
So that is 1 year, 8 days. The grounds of appeal on ground one make 3 points. Firstly, the judge erred in her approach to the immigration detention comparative cases.
Yeah.
Secondly, that the judge erred in undertaking a further personal injury cross-check. And thirdly, the judge erred in placing reliance on the appellant having been lawfully detained post-charge. I'm going to deal with the second and third matters very briefly at the end. I'll return to them once I've dealt with the central issue, which is the approach to the immigration detention cases. Now, the relevant parts of the judgment, which assist in understanding the judge's reasoning in reaching the figure of £60,000 for loss of liberty, are summarised at paragraphs 6 and 7 of the appeal skeleton argument, which can be found at tab 3 of the appeal bundle, and most specifically at pages 15 and 16 of that. And I'm going to take you to the various passages in a little bit of detail, but not too much detail. The judgment itself, and it's probably...
Just in terms of timetabling, how long do you think you're likely to be in your total submissions? We've read the papers.
Yes, an hour and a half, I would have thought, maybe.
Must be no more than that.
That's exactly the same.
Right, so let's try and bring us in by 1 o'clock, shall we?
Right, okay, certainly, we'll try to. Okay, so judgment itself is at tab 7. Sorry, please have disappeared.
Tab 5.
Sorry, apologies, tab 5. My notation error. Tab 5 of the bundle. Now, at the outset, it is important to note that the judge accepted the appellant's argument that the award for distress relating to the malicious prosecution should be separated from her award for loss of liberty, and the judge expressly noted at paragraph 24 of the judgment, which is page 31 of the appeal bundle, that it was important to avoid double counting. My Lord, given your comments about having fully read it all, I'm just going to give you the references rather than reading into all of the bits of the judgment, unless you specifically want me to on any particular point. No issue has been taken, or is subsequently taken, with that approach, the separation of the damages for malicious prosecution, distress, and the loss of liberty. Now, turning to the judgment itself, the conclusions in terms of loss of liberty are at paragraph 54 of the judgment. So I'm going to look at that first before seeing how the judge got to that ultimate conclusion. At paragraph 54, which is page 37 of the bundle, the judge recognised the accepted tapering effect of a long period in custody. She notes that she included in terms of her loss of liberty award an uplift to the award for time spent in category A conditions. She also states that she has included an uplift for the time spent in restricted bail conditions, and makes it clear that her distress award, the malicious prosecution distress award, was separate from the loss of liberty award.
Yes. So
that's the ultimate conclusion. Just in terms of then how she gets there in terms of the judgment. At paragraph, we can turn first to paragraph 20 of the judgment, which appears at page 31 of the appeal bundle. So, again, without reading it, the propositions in my submission that come out from paragraph 20 of the judgment are: the judge indicates her intention to reduce the loss of liberty award due to the claimant's prior experience of custody, but she differentiates that from the malicious prosecution distress award, in which she indicates that the degree of reduction owing to the claimant's prior conviction would be modest in relation to the gravity of the charge. So again, that's
a 10% reduction.
Yeah.
And that's not challenged on appeal.
No. So that's paragraph 20. Then turn to paragraph 25, which is at the bottom of that page. At paragraph 25, she details the factors relevant to her award for loss of liberty, and she talks about, obviously, the length of the loss of liberty and the degree of loss of liberty, i.e., on the one hand, the most extreme, the category A detention, and at the least extreme, but still a loss of liberty, the restricted bail conditions. Then, turning over the page to paragraph 27, she again makes the point that the damages for loss of liberty will be diminished where a prisoner is in lawful custody already. We turn over the page to paragraph 32. This is at page 33 of the bundle. And at paragraph 32, she's considering submissions in relation to Gary Vian and the submissions of Mr. Simblet, but she's obviously also making some general comments in terms of her approach. She's talking about his loss of liberty award, and she again refers to, as relevant factors, to the lack of initial shock, the familiarity with custody, and the fact that in Mr. Vian's case, he'd been a serving prisoner for most of the time he was under the murder charge. Yeah. But then, importantly, she expressly distinguishes those elements of the claim from the humiliation, reputational loss, and distress caused by the charge and the proceedings, which were matters relevant to the distress element of the award. Final two...
Yes, it's not entirely separate from reputational loss, is it?
Sorry, loss of liberty?
Well, what I'm saying is, I think in the context in which she's talking about, there's some overlap, isn't there, between reputational loss and the fact that you've been in custody before.
Well, well, yes. I mean, if insofar as
that's in defamation.
Yeah, of course. If you've been in prison before, it's not going to be as embarrassing that you're in prison again. Absolutely. But the important point for the purposes of my submissions, we'll come on to why that's relevant in a moment, is that she cites the loss of reputation, which she accepts as a relevant part of the claim, but that's nothing to do with loss of liberty as far as she's concerned. In this case, that's about the loss of reputation from being charged with murder, which is obviously a very serious offence, far beyond the experience, certainly, of my client in this case previously. So the final two passages from the judgment are paragraphs 50 and 51 of the judgment, which appear at page 36 of the appeal bundle. This is where she identifies the different elements of the distress and loss of liberty awards. At paragraph 50, the distress element, she says, relates to the anxiety and stress of being prosecuted for a high-profile murder and the risk of conviction with a mandatory life sentence. That's what she's looking at for the distress element. And 51, conversely, the loss of liberty was to recognise the loss of liberty was to recognise the period of time in custody on the murder charge, as well as the level of shock caused, or in the present case, obviously not caused, by the arrest and detention.
Yep.
So I'll pause there for a moment. That's my sort of brief review of the relevant passages of the judgment for purposes of the submissions. There is no suggestion on this appeal that any of that was inconsistent with the guidance provided by the Court of Appeal in Thompson and Sue, which is obviously the Court of Appeal case which provides the guidelines on which the courts look at loss of liberty awards, malicious prosecution, and indeed exemplary damages.
Yep.
The respondent sets out what are said to be the accepted general principles to be applied in assessing damages for loss of liberty at paragraph 18 of the respondent's appeal skeleton argument, which you can see at pages 79 and 80 the bundle. To 80 the bundle.
I think they've been renumbered, Mr. Young.
Oh, I see. Yes.
Tab 4. Page, we've got it as page. Is it paragraph 18 of the skeleton?
Oh, I see. Yes, that's been my
25.
Yes, I think. Unfortunately, I've been handed a duff copy. But anyway, right. So you have it in any event. Yes. Oh, I see. So I was looking at the internal pagination on 79, whereas it's 25C. Yes, grateful for that. So yes, 18, paragraph 18, respondent sets those principles out. Now, I'm just going to take a few moments to review those principles and set out the appellant's position on them, because they are relevant to the judge's approach to the quantification of the appellant's damages and the respondent's defence to that approach. So, going through them, it is accepted that the conditions of detention will be relevant. The loss of residual liberty will lead to an enhancement of an award, and you'll see that that's 18.4. I'm just going to go through the ones which we agree with totally first. 18.4 of the known friend skeleton argument. At 18.5, it's agreed and accepted that damages are recoverable for loss of liberty due to restricted bail conditions. Reliance there is placed on the case of Jolla. The length of time, this is 18.1, for which a person loses their liberty is a significant factor, though there is no linear relationship between the time and the award, and there's no daily tariff, and of course that's because of the tapering effect. And that's 18.1. 18.2, this is where there is some distance or, between the parties. We accept it's important to differentiate between cases where detention from the outset is unlawful, so those with an initial shock element, from those cases where an individual was previously lawfully detained. So we accept that, but there is some disagreement here, because at 18b, or 18.2 of the respondent's skeleton argument, it is suggested that awards where there's an initial shock element are invariably significantly greater than those where that element is missing. Now, the appellant accepts that the award will be higher where there is an initial shock element. It is not accepted, however, that that discrepancy will always be significant, regardless of the overall length of the detention. And we say this is a relatively simple point. The impact of the initial shock will be proportionately greater where there is a shorter period of detention. When the detention is more extensive, the impact of the lack of the initial shock will gradually reduce because the overall damages will be greater. Now, my learned friends rely on the case of Barnett and Wilkinson and Chief Constable of West Yorkshire Police in this regard. And you'll see...
Well,
yeah.
What you would accept is, was the loss of liberty occasioned by wrongful arrest are invariably greater and sometimes significantly so.
Yeah.
So should we not dance?
No need to go into that.
I don't think Mr. Beer would disagree with that.
Okay, quite happy with that. And that's exactly what we say the approach. It's not always the case. Will be greater, but not always significantly greater.
Nothing is always the case in assessments of damages in these situations.
Well, everything's fact sensitive. Yes, indeed, absolutely. So that deals with 18.2. And then looking at 18.3, it's equally accepted that the character of a claimant, insofar as it relates to their previous experience of incarceration, will be relevant. But it's not accepted that bad character per se will operate to reduce a loss of liberty award. It's only when that bad character gives rise to a previous experience of incarceration. So you may have somebody who's got, for example, a conviction for shoplifting, or a variety of convictions for relatively minor offences for which they've never received a custodial sentence. In the circumstances of those individuals, the impact of there will be, we would contend, no impact on the loss of liberty award arising from the fact that they have previous convictions. It's only where those previous convictions give rise to the fact that they had been previously incarcerated, and therefore they are more used to the loss of liberty. So that's the first qualification that the appellants would seek to make in relation to that particular citation of principle. The other qualification is, in its appellant's case, that the longer a detention goes on for, the more used to detention the individual will become. So it follows that as time goes on, the extent to which damages will be enhanced for a person with no previous experience of detention will diminish. And the converse is equally true. The impact of the reduction made for an individual with prior experience of incarceration will reduce the longer the detention persists. The short point we make in relation to this is that there is no scope in the context for loss of liberty awards for applying a tariff deduction. And that's what, if you look at 18.3, certainly with reliance on Clark and Chief Constable of Cleveland Police, there is reference there to previous conviction and character justifying around about 50% reduction in the award which would otherwise have been applied. Now, just on, and again, I appreciate the court doesn't want to drive into these issues in too much detail, and they are, to a certain extent, scene setting, but the point to be made, important point to make with Clark, and I can develop this more if need be in reply, is that Clark, which is at tab 7 of the authorities bundle, the reduction is made in relation to a malicious prosecution award, not loss of liberty. So we accept, and we've seen this before, because of course your reputation is going to be less damaged if you are a person who has previous convictions, and therefore your entitlement to a higher award for malicious prosecution will be reduced where you've got previous convictions. And that's what the court was saying in Clark when making the reduction on account of the fact the individual had previous convictions from their malicious prosecution award. The court's considering that aspect of an award, not the loss of liberty there. Now, I can take you to that if you want, or I can make the point and we can come back to it if need be in reply.
Move on.
Okay.
Thank you.
So, with that foundation, I'll turn then specifically to the approach in the present case. The difficulty the judge had in this case in applying the accepted Thompson and Hsu guidelines is the same difficulty, in fact, which Mr. Justice J pointed out in the AXD case regarding the tapering effect. Now, he described it as the difficulty arises from the progressively reducing scale of awards as time elapses. The short point is it's difficult to apply the Thompson guidelines, which related to relatively short periods of detention, to longer periods of detention, particularly because the tapering effect means you can't adopt a linear approach or a daily tariff approach. So that was the difficulty that the judge faced in the present case. And in terms of the longer length of detention, the parties took different approaches. The respondent placed at first instance reliance on the statutory compensation cases of O'Brien and Miller. And those are cases which are cited again at paragraphs 19b and c, and indeed d, of my learned friends' skeleton argument before you. The judgment of Mr. Justice Cheema-Grubb does refer to those cases, but doesn't suggest that she found them of any particular assistance. The appellant's case is that they don't provide any real assistance in determining the proper level of damages in the present case, and the various shortcomings of those cases as comparators were set out in the speaking note before the judge at first instance, which, and I'm just going to give you again the position for this, and we can go to it if need be in due course. At paragraph 72 of the appellant's speaking note at first instance, which you'll find at page 61 of the appeal bundle. And again, I don't propose to go through those arguments in detail as to why those statutory compensation cases were not particularly helpful, but I will do if necessary in reply. And it's at this point that I now turn to the crux.
Speaking for myself, I tend not to pay much attention to speaking notes at a hearing below. What we're interested in, the arguments addressed to us.
No, absolutely, but I'm just saying, just in terms of, that is where the body of the argument in terms of why we say statutory compensation cases were not particularly of any particular assistance. I'm not proposing to...
Yeah. This is all a variation. I'm saying ultimately all these cases are fact specific. Yeah. I mean, we have obviously principles, but to work to.
No,
but the
well, that's absolutely right, and actually that comes on to the core of my submission before you, which I'm going to come to now, which is this. So before Cheema-Grubb, the appellant relied on the comparative cases in immigration detention context, and this was to assist the judge, obviously, in coming up with an appropriate level of damages in longer periods of detention. The appellant's central submission on this appeal is that the judge erred in principle at paragraph 28 of her judgment, where she rejected the utility of awards in immigration detention cases as comparators, implicitly suggesting that such awards would generally be higher than those in non-immigration cases. And in doing so, she accepted at paragraph 28 of her judgment the respondent's arguments that, the three particular ones that she cites, first, that such judgments did not break the awards into individual constituent parts of distress and loss of liberty. Secondly, that the context was different, as in immigration cases often involved the return of an individual to a country where an individual would fear persecution. And third, that in immigration cases, the detention had no clear prospective determination, as there would be in the context of a criminal trial, where following a criminal trial there'd be some expectation of release. Now,
you submitted that she rejected them as comparators, but she didn't reject them. She said that they weren't ideal comparators. There is a difference.
Well, the central point that the appellant makes is that, and it's a point, my lord, that you've made to me on a number of occasions already this morning, is that all cases should be treated on their own facts. So, of course, it was for her to reach, as she described, a bespoke ultimate assessment as to the quantum for loss of liberty in this case. But that when also it follows from that when considering awards made in other cases, and of course she's not bound by the awards made in other cases, she should be looking at the factors specific to those particular cases and seeing how they relate or they don't relate to the particular case before her. The issue, and the principal issue that the appellant takes on this appeal, is that what the judge did was, rather than, so when, for example, she was provided with the comparative case of AXD, rather than looking at the similarities between AXD, the differences, and then reaching her own conclusion based on the facts of this particular case, what she did was form generalised conclusions as to how useful immigration detention cases would be in terms of assisting her on reaching the appropriate level of award. And by doing that, did not give sufficient regard to the similarities in the factors present in, for example, the AXD case, between that case and the present case, which is before her. Now, it's absolutely right, and I entirely accept that comparative cases should not place the judge within a straitjacket in terms of her discretion as to the appropriate award. But as I said, the key point is that she shouldn't undermine the utility of an immigration detention case on the basis of generalised concerns about that category of cases.
But is that a fair construction of that sentence in paragraph 28? Because there are two possibilities. She's either expressing an a priori view about the immigration cases, or she's saying, having looked at the immigration cases, my view is.
Yeah, well, she starts off, she says, it starts off in terms of that passage, Mr. Bowden submits the unlawful immigration detention cases are a legitimate comparator, and then refers to the fact he cited some examples. Mr. Johnson urges caution because, and then he gives the three areas of caution which he urges upon her. And then she goes on sort of halfway down, I have not found these awards ideal comparators, largely for the reasons identified by the defendant, but some have provided a general, more or less contemporary check to the claims made in the defendant's counter-submission. Now, I accept she has not completely ignored, for example, AXD. I couldn't make that submission. It's obvious she's referred to it, and she's referred to the award that's made there. The point that's being made by the appellant, is that she has unfairly, on the basis of generalised concerns about those cases, given significantly less regard to the similarities between, for example, AXD and the present case, which resulted in her, the ultimate result, in her giving a very significantly lower award for loss of liberty in the present case than she gave in, than was given in the case of AXD. So we say that, I mean, ultimately, of course, you will have to make your own judgments as to how you construe paragraph 28 of her judgment. But what I say is this: when one looks at I mean, there is a very significant disparity between the figures that the judge awarded and those that were awarded in AXD. In AXD, the award at the time in AXD was £80,000, uplifted as is appropriate, as at the date of the hearing before Cheema-Grubb, that was £86,290. And of course, the present case, £60,000 was awarded. But perhaps what's even more stark is that in AXD, Mr. Justice J also gave an alternative quantum figure based on different periods of unlawful detention. And I think perhaps it's probably quite useful to have a quick look at this, very briefly, because AXD really is the key comparative case that was referred to that we rely on. So, if we look at AXD, which you'll find at tab 26 of the appeal bundle.
Are you saying that judges assessing awards of damages in immigration detention cases should be looking at decisions of Queen's Bench judges on awards of damages in false and malicious prosecution cases?
Yeah, our central point is there shouldn't be any.
You said they should just coalesce and.
Yeah, these are loss of liberty awards. But the key point is look at the individual facts of the case. Don't draw generalised conclusions about sorts of cases and types of cases, and therefore place them into different silos. Now, the practical reality is that false imprisonment, malicious prosecution cases, there are not very many authorities that deal with lengthy periods of detention. That is why, in this case, practically, the immigration detention cases were relied upon. Now, that's effectively the central point. There should be no siloing, no categorisation in these cases. As a matter of principle, judges should be looking at all of the cases, looking at the similarities of the facts and the differences, and use that to assist them in coming to the ultimate figure that they reach in terms of quantifying the loss of liberty award. I've taken you to paragraph 43 of Mr. Justice J's judgment, simply because it's a point which exemplifies the starkness of the difference between what was awarded in the present case and Mr. Justice J's approach. So paragraph 43, he indicates the £80,000, which we've already talked about, which is uplifted to £86,290. But he also talks about alternative formulations, 11 months and 5 days. The basic award at that point would have been £58,000. Now, uplifted as of up to the date of the hearing before Ms. Cheema-Grubb, that was an award that would have been £62,560. So that would have been an award in excess of what was ultimately awarded to the appellant in this case. And that is for a period of 11 months and 5 days in unlawful detention, or 339 days, which is less than half the period of unlawful detention that the appellant experienced in the present case. It's also, it's not referred to here, but I'll show you where it's referred to in a subsequent case. It's also the case that 39% of that 11 months and 5 days was spent in the prison estate, whereas, of course, in the, and I'll take you to where that comes from in a minute, whereas in the present case, the entirety of the appellant's detention was on the prison estate, including 5 months in Category A conditions. I get the 39% from the subsequent case of Home Office, of Mohammed and Home Office, which appears at tab 28 of the authorities bundle, and at paragraph 37 of the judgment there of Edward Pepperell QC, Deputy High Court Judge. He is reviewing AXD, starts at 36 AXD, and then helpfully provides a little table as to what the conclusions were in AXD. And you can see the bit that I've referred to, the 339 days, £58,000 award, and he refers to having calculated there himself 39% portion of it in the prison estate. Mm. So I make that point because I say that the erroneous approach that the judge takes in terms of not placing sufficient reliance upon AXD because she has generalised concerns about immigration detention cases, in my submission, leads to a very stark result, namely very significantly lower awards for loss of liberty.
In the case of Belfkin, the High Court judge awarded £40,000 for 295 days unlawful detention.
Yeah, that was a case where, and that's at tab 27 yes. of the bundle, where the individual, paragraph 5 of the judgment, was described as having an appalling criminal history, and that the paragraph 91 of that judgment of Karen Steen QC, she refers to the fact that the £40,000 reflects the fact that the claimant had been uncooperative and obstructive.
You see, but you've in effect picked out AXD as the plum in your pie.
Yeah.
And then you're saying, and that's the case that everyone should be following. But it all depends.
I completely accept that it depends. All cases are fact-specific. I completely accept that. When a case is set before a judge, and in this instance, a number of immigration detention cases were set before the judge, but focus was placed upon AXD because it was an extensive period of detention, and a period of detention, the longer period of detention, was close to the period of loss of liberty in the present case. And we say that in those circumstances, it was incumbent upon the judge to have a look at what was going on in AXD, have a look at what's going on in the present case, and entirely open to her to award something lower, but there has to be some justification for that.
But why did the judge err in law? Because she never said, I totally discount and ignore the immigration detention cases. In effect, she accepted Mr. Johnson's submission that she'd approach them with some caution.
Yeah.
But she never ignored them.
Yeah, but the principled complaint that the appellant makes is that insofar as one can say, well, all cases should be treated as caution because all cases are fact-specific, well, I can't take any issue with that.
And there are some principles, Thompson and the...
Our point is there is no basis for saying treat the immigration cases with particular caution. The approach should be look at all cases, consider all of their circumstances and facts, and draw your conclusions as to what award you should make. And there shouldn't be a distinction between, well, this is well, we've got to be careful about this because this is an immigration detention case, or this is a case in another context.
But you pointed out the different features that can apply in immigration cases. There are different features that can apply.
There are different features that can apply
people,
in
for
certain...
example, thinking, am I going to return to a country where I may be persecuted? I mean, these are different features.
And the point she makes about it being open-ended, that the person in question hasn't got any idea how long he or she is going to be detained. Whereas in the case of somebody in the position of your client, he would know that once the trial came, if he were innocent and was found innocent, then that would be the end of it.
Also, sorry, if I can just ask you to look at paragraph 41 of AXD, please.
Sure, yes.
Mr. Justice J effectively recognised in that paragraph that this is just a case of sticking a finger in the air and making an award that reflects the overall justice of the case. So how is that something that binds or that bound Mrs. Justice Cheema-Grubb?
Well, I'm not saying it does bind her at all. That's not my submission. My submission is cases are put before her. She must reach her own decision based on the individual facts of the case, applying the principles that we talked about earlier. But what was not open to her, and this is the key thrust of the appeal in this regard, what was not open for her is to, and I'm going to come on to what your Lordship's mentioned in a moment, just in terms of those three areas which potentially differentiated immigration detention cases. But what was not open to her, I would submit, is to have a generalised sense of caution in relation to a particular category of cases. What she had to do was to look at the facts of the individual comparatives that put before her, but again, accept entirely, she must reach her own conclusion.
It would be lamentable if assessments of damages descended to judges being taken to a series of 12 other cases and then being invited minutely to try and decide what facts were in common and what facts were different from the case under consideration. It would be lamentable.
I accept that kind of forensic analysis. It is not necessarily required. But if a judge is going to rely on, as she does in this case, at paragraph, when she deals with the approach to AXD, and she sets out her some generalised concerns in reliance on what had been said to her by Jeremy Johnson QC, if she is going to place reliance on those concerns, that has to be well-founded. In my submission, that was not a well-founded reliance.
I mean, the difficulty with this is that Mr. Johnson made some generalised. He said that caution should be exercised in relation to the immigration detention cases for the three reasons he gave, which the judge does accept, but she goes on to say some of those cases have provided a general, more or less contemporary check to the claims made in the present case. And then she looks specifically at AXD, where the detainee was detained for 2 years, subjected to physical and verbal abuse because of his sexual orientation, and feared being returned to Somalia to persecution.
Yep.
So those factors, or at least one of the factors that Mr. Johnson had identified was present in that case, together with the fact that he was abused in prison.
Yeah.
So if what she's doing there, she's saying, well, I've got to hear these cases provide some sort of cross-check.
Yeah.
80,000 in that case, but falls to be reduced in the present sort of case, where those factors are not present.
Yeah. But
what's wrong with that?
Well, it's important. In terms of that, if I can take you through each of those factors, it won't take probably more than sort of 10, 15 minutes. The point that I'll make, the overall point that I make, is that whilst clearly all cases are different, and there were some differences between the AXD case and the factors applicable in the present case, on analysis of what was said by Mr. Justice J in AXD, those differentiating factors could not possibly have resulted in the effectively halving of the award, which is made to to the appellant in the present case. Can I take you to those three generalised concerns and then the two very specific points that came from AXD?
Of course.
Grateful. The three generalised concerns that that were raised, which were accepted by the judge. First one was the absence of a breakdown in the award between loss of liberty and the mental distress elements in the immigration detention cases. The suggestion, as far as I understand it, is that since the judge in the present case made a separate award for distress and for loss of liberty, the failure to distinguish between those elements of the awards in immigration detention cases means that those awards would be commensurately higher because, for example, there might be a distress element included in the immigration detention awards.
Well, in AXD, that would have been a significant factor.
Well, in my submission, that point doesn't run because in the present case, the distress element, the separate distress award, relates solely to the distress arising from the malicious prosecution. Now, I took you, when we went through a little bit of detail through the judgment earlier, at the way in which the judge differentiated between distress relating to malicious prosecution arising from, for example, damage to reputation and the fear about a murder charge and that kind of thing, and the way she dealt with loss of liberty and the, for better words, the injury to feelings that one suffers from losing one's liberty, and she differentiated between the two of them. So the separate element of distress and anxiety which relates to expressly to the loss of liberty was awarded in this case in the context of the loss of liberty award. And that's in my submission, no different to the distress and anxiety elements of the loss of liberty award in the immigration detention cases.
But, I'm sorry, I'm not following that. In these kinds of cases, it is conventional to attribute damages to loss of liberty and damages to distress.
Yeah.
Whereas in immigration detention cases, the custom is to give a globalised award. Yeah?
Yeah.
In AXD, one can infer from the findings of fact in that case that the distress element in the global award will have been very significant indeed because of all the persecution that AXD had whilst in detention, his anxieties and concerns what was going to happen to him. So that was going to be, one can infer, a significant element in the global award. Well, but those considerations of that kind aren't present in this case. Well, there are other considerations, but not those.
Well, at the outset of my submissions, when I took you through the structure of the judge's judgment below, I attempted to show you that the way the judge was very specific in the way that she dealt with the distinction between malicious prosecution, and which she called that the distress award, but that related to malicious prosecution, and then what she said about what constituted the loss of liberty award. And I took you to paragraphs 20, 25, 27, 32. So, and for example, I mean, a good example, for example, was with paragraph 32 when she was talking about Gary Viam, where she says, in terms of loss of liberty, the factors are, relevant factors are the lack of initial shock, familiarity with custody, the fact that he's been serving prisoner, distinguishing that from elements of the claim for humiliation, reputational loss and distress caused by the charge in the proceedings. So being detained and the stress that caused by being detained, in my submission, is plainly something which this judge awarded in the silo of loss of liberty. The extra element, namely the fact that this was an individual who was being prosecuted on a murder charge and the reputational damage arising from that was separately awarded in the malicious prosecution claim. There is no analogue in the immigration detention cases. In immigration detention cases, a person is being awarded damages for their loss of liberty arising from their stress by being detained. And I accept there will be cases where an individual fears return to the country where they came from and potentially persecution. And that, of course, all forms part of that, that award. But in my submission, there is an analogue to that in the present case, which is that you've got the distress award, which relates to malicious prosecution and the fear of the murder charge and potentially being convicted. But separate to that, you've got all of the anxiety and distress which arises from the fact that these are individuals, or the appellant is an individual who is being who's lost their liberty, who's been placed in restrictive conditions. So the point that I make is the distress element which the judge separated off in the present case was separate from the distress element relating to loss of liberty, which is similar in the immigration detention awards. So for that reason, in my submission, the contention that one must exercise wariness about immigration detention awards because there is no separation between the mental distress elements relating to loss of liberty and the loss of liberty aspect itself, in my submission, doesn't go anywhere. And in particular, in relation, and I'll come on to the specifically AXD in a moment, there's no suggestion that there's, for example, a malicious prosecution or something along those lines.
The distress element in a case like AXD,
yeah.
I mean, I follow your submission about that there is an element of distress, if you like, that needs to be catered for in the loss of liberty award in the present case. But the distress element, as my lord said a moment ago, the distress elements identified in AXD on the facts is absent in the present case. I mean, there's no evidence that your client was physically or sexually abused in prison or anything of that kind. There's no evidence that he had an anxiety about being sent to another country where he'd be persecuted. Those elements are completely absent. And therefore, you know, appreciating it is very difficult where the immigration detention cases don't divide up the total amount. What one can deduce, can one not, that of the 80,000, a considerable proportion was attributable to those factual elements.
So I accept entirely that fear of risk of return to a country where a person may be subjected to ill treatment is a factor which may lead to an enhancement.
And that, in very general terms, would provide a justification for a judge in the position of this judge for concluding that whilst those cases are of some assistance, one has to approach them with some caution and perhaps end up awarding less because those factors are not present in this case.
So my lord, I have a general point and a specific point in response to that. So the general point is that in not all immigration cases will you have a situation where you've got a person fearing ill treatment on return. So
well, in those cases, the award is correspondingly less.
So, but that's a reason why a generalised approach shouldn't be taken, because that isn't a factor which is applicable in each case. The specific point that I make, and I accept that, particularly on AXD, that was a factor which was present in the case, but because the obligation, we say the obligation on a judge, central obligation, which my submission not particularly contentious, is a judge must look at the facts and see how they're similar or they're not similar. It's important to look at what actually was said in AXD about the fear on return.
Well, we're being asked to look at AXD as a decision of the Supreme Court.
No, not at all. No, of course it's not. But my point is that what the appellant challenges in this case is a case was presented with similar periods of loss of liberty to the present case. The end result is as I pointed out before, the starkness of a result of a very significantly lower award of loss of liberty. Factors are presented by the judge as justification for saying, well, this is why I've come up with this lower award. There are general and specific factors.
She doesn't have to justify coming up with a lower award than AXD. She doesn't have to do that. You're sort of saying AXD is the benchmark, which the judge was obliged to distinguish. It doesn't work that way. It's simply one of the many comparative cases which he was to take into account. Otherwise, we're going to get in most terrible trouble if we adopt your approach.
No, to be clear, the approach that I'm advocating is not you have to provide detailed forensic analysis and as to why a particular case should have higher or lower damages. The general principal point made on this appeal is that you shouldn't categorise certain sorts of cases and place them into silos and give them more...
Well, I've got that point.
Right.
That's written it down in my book.
Yeah, well, and so it follows from that, and we say that is the error that the judge made.
All right.
And what I'm seeking
so what's the next? What's the next?
What I'm seeking what must follow from my general proposition is why is that material in the case? And we say it's material in the case because we can see that that has manifested itself in a significant difference in the awards made between the two sorts of cases. And if I can just make I think it's three short points on AXD, and then I'll move on, because it's important, because the particular point has been made on a number of occasions which in my submission isn't borne out on AXD. It is said, two things were said. First of all, it was said that, well, in AXD, the judge was right to have regard to the fact that, Mrs. Cheema-Grubb was right to have regard to the fact that AXD feared return to Somalia. And I accept that. However, it's important to note that paragraph 39 of the judgment of Mr. Justice J, he expressly found that the fear on return to Somalia would enhance the award only to a modest extent. First point. Second point, the very next paragraph, again, the award did take count of the receipt of unpleasant verbal abuse and one occasion of physical assault whilst in detention. This is in the instance of AXD, and that's paragraph 8, but again also paragraph 40. But again, the judge expressly weighed against, this is paragraph 40, weighed against AXD the fact that his antisocial personality disorder exacerbated his problems. So, I accept that there were factors in AXD which were not present plainly in the current case, and there were factors in AXD which would justify the award in the present case being lower than what was awarded in AXD. But insofar as those are specific factors to AXD, it's clear from the judgment in AXD that the judge indicated that those factors only resulted in a modest enhancement of the award.
But is your argument really an argument that AXD is some kind of binding factual precedent? And if that's your argument, I don't see how that's reconcilable with paragraph 41 of Mr. Justice J's judgment, which I've already mentioned. He's saying, effectively, I've put my finger in the air and this award reflects my overall sense of the justice of things. But I just don't understand how that would help Mrs. Justice Cheema-Grubb in arriving at the right award in this case.
I'm absolutely not suggesting that AXD is any form of factual precedent. That's certainly not my submission.
Right.
If
that's so, can we perhaps no longer have any more reference to it?
Okay.
Right? And shall we move on to our next point?
Right, well, that is the point which you've got on the immigration detention comparative cases. The central submission is they shouldn't be placed... No silos. She had a case before her, similar periods of time, has to be proper basis for distinguishing between them. I make one final point.
Ultimately, what you're saying is that overall she came up with a figure which was just too low.
Yeah, but it's explained by point of principle.
Are you saying her... Because you can get to the right result by the wrong reasoning. Okay?
Yeah.
But are you saying that in fact the figure she selected was one which no reasonable judge could have selected?
Well, yes, that's absolutely right.
You are saying that's what we need to consider. Was it simply too low a figure to be acceptable?
But we explain that, and in terms of the point of principle that we've come to, we explain that by saying that is because of this generalised principled error. And if anything we come away from in terms of your judgment, we would be clear that cases should not be separated off into these separate silos. I'm going to make one final point and then move on completely, which is...
You might find we say that the courts shouldn't be bothered too much with citation of too many authorities in this field, but anyway, we'll wait and see.
My final point, I'm just going to make this, and then I promise you I'll move on to other issues, is this, because one final generalised concern about immigration detention cases is a legitimate point, which is the open-ended nature of immigration detention, because as we all know, there are no statutory limits, and the court simply has to apply common law principles in terms of determining at what point immigration detention becomes unlawful. But that particular differentiating factor, again, isn't applicable in all cases, and in particular wasn't applicable in the current case, because these were individuals who were facing potential life imprisonment on a charge of murder, in circumstances where they were the victims of unlawful acts by a very senior police officer. So they had no realistic expectation that they would be released on trial. So that, again, in my submission, is an important point. And again, a point which
and
indicates...
You can also, for example, stress that this was on a murder charge.
Yeah.
Of itself, you know.
Yeah. Yeah, but the additional fact that they're not even going to get it, you know, from their perspective, not going to get a fair trial, that makes it even worse.
Absolutely, I understood that point.
Okay,
right.
So, Mel, those are my submissions on that central point about the immigration comparator detention cases. As I indicated at the outset, I was going to deal very briefly with the other two aspects of the case, because on analysis, on the personal injury cross-check, our simple point is, in Thompson, the Court of Appeal arrived at its guideline figures having undertaken a personal injury cross-check. Those cases, Thompson has provided the basis for the awards in all of the subsequent cases, because everybody accepts that Thompson is the correct approach. And indeed, there are cases, for example, Home Office Mohammed, which is tab 28 of the bundle, where personal injury cross-check was referred to, but it was not suggested that any further personal injury cross-check should be undertaken. Well, the simple point is, given the fact that in all of the cases relied on, the figures have been arrived at based on a consideration of cases and a line of cases which stems back to Thompson, where a personal injury cross-check was undertaken, there was no necessity to undertake a further personal injury cross-check. But if I make this point, then perhaps you might not be a Christian, but I accept that we don't know in the present case whether this is if it's an error, whether this is a material error, because of course we don't know whether, when the judge says, "Oh, I've undertaken a personal further cross-check," whether that resulted in her lowering, reducing, or being happy with the award she's given, or indeed making sure that she gave a greater award. So I accept, and I have to accept, that whilst there is a point there as to whether it's necessary to undertake a personal injury cross-check, in the context of this judgment, I don't know whether it takes me anywhere, because I don't know whether she...
It doesn't get you anywhere, because you just don't know.
Yeah, no, exactly. And I have to say, Milady, I apologise, I interrupted you.
No, I was about to interrupt you. It's my fault. Look, I just want to understand this point, because Thompson is a number of years ago now.
Yeah.
What if the position is that the difference between awards for detention and personal injury damages has changed in that period, such that you get more now by undertaking a personal injury cross-check? I mean, would you say that was wrong in principle?
To double-check that you haven't, that the awards have not completely...
Too little.
Yeah. Well, I mean, it's ultimately, as I indicated...
But I mean, isn't that
I mean, I just don't see the point here. It seems to me, if what you're doing is you're looking at a case which is now a number of years ago, more than 20 years ago, on the one hand, and looking at the position as today, or as last year in the case of this judgment, it seems to me the judge was absolutely right to do a cross-check against the sorts of awards of damages that are made in personal injury cases today, as opposed to when was Thompson, 97?
Yeah.
And I mean, I don't know whether awards for moderately severe PTSD were...
I think they have gone up. There've been several
well,
additions to the guidelines, and they've increased.
Yeah.
I must say, I mean, to me, this is almost like a car mechanic servicing a car. Amongst other things, he takes the wheels off, puts them back on, tightens the nuts, does everything else, and then he goes back and checks again whether the nuts are indeed tight. What's wrong with that?
Well, as I say, I'm not pushing the point.
Right,
I see that. Well, that was my rush to my end point.
I think that's probably not the heart of your
opinion. No, I accept that. That's why I said I can't do it very briefly. Right. The other, just for crossing the T's and dotting the I's.
Right.
The other final point was made, and again, very briefly, paragraph 17 to 19, the skeleton argument, is the apparent reliance that Judge Pearce have made on the appellant having been detained lawfully on a false charge.
Sorry, yes? Sorry, say it again, sorry.
So, paragraph 51.
Paragraph
51 of the judgment.
Yep.
The judge appears to have relied on the appellant having been detained lawfully on a false charge. Now that, of course, is factually incorrect, because he was detained lawfully, arrested and detained pre-charge, and then once he was charged, that was the start of the unlawful detention. But, and again, there's a but here, before anyone jumps in, I concede that it's not easy to determine whether, if there was an error there, that error made any material difference, because given that the appellant was lawfully detained pre-charge, prior to his unlawful post-charge detention, the issues in terms of initial shock of detention, etc., would not apply because there was an initial lawful detention. So, whilst on the face of it, it looks like the judge may have got that factually wrong, I have to accept that it's difficult to work out whether that's material or not, because the loss of initial shock will be there in any event. So, that's my ground one. I'm going to turn on to ground two, which is on interest.
Yes.
And the question as to whether pre-judgment interest should be payable on any award of damages, as distinct from post-judgment interest, was expressly raised before the judge.
Was it raised on behalf of your client?
Well, it was raised generally, but by the third claimant. It was represented.
But was it raised on behalf of your client?
Well, I don't recollect whether Mr. Bowen specifically made submissions on it.
I think what's said against you, it wasn't raised by your side, either in writing or orally.
Well,
we do benefit from the speaking note to that extent. It's not in the speaking note.
It's not in there, is it?
Well, there were many submissions that were made by Mr. Simbler, which Mr. Bowen then said, well, I'm happy to adopt that submission as well. So certainly we would say that the interest arguments form part of the overall argument which was before the court.
Was there a claim form of some kind?
Well, I don't
think that was in the bundle.
No, we've not got the pleadings in the bundle.
We haven't. Have you got them anywhere?
Yes.
Was interest claimed on the face of the pleadings?
I suspect it was, but we'll check.
I could check, please. Thank you.
Do you want me to make my... We can wait. Shall I make my submissions in any event? I should say, I think this is quite an important point. Having looked at it in a bit more detail, there is a complete lack of clarity here, and actually it might be a persistence the Court of Appeal does give some guidance on it. I mean, the judge doesn't deal with it. I think that we can see that because paragraph 56 of the judgment, there is no reference to it at all. Of course, we say judge has. It's incumbent upon her to give reasons for failing to grant that interest, but of course you will be interested in whether that's material or not. We say it is material because pre-judgment interest, there's one of two things, either pre-judgment interest should have been awarded, or in the alternative, the authorities suggest the damages should have been increased to take account of the time it had taken for the claimants or the appellant to get justice. The starting point, and I've probably got about, say, there's about 10, 15 minutes of submissions on this. The starting point is section 35A of the Senior Courts Act, which is now in your bundles at 1A.
Yeah.
And I'm sure your lordships are aware of the provision. It gives the court a discretion to award simple interest on any damages, including part of the damages awarded in a judgment at such rates court sees fit, and for all or any of the period between the date of the cause of action arose and the date of judgment. And the Act at section 35A2 draws an important distinction between personal injury and non-personal injury cases at section 35A2, making pre-judgment interest mandatory in damages for personal injury or death awards exceeding £200. We say that the governing principle is that an award of interest is not awarded as compensation for the damage done, but as compensation to the claimant for being kept out of the money which should have been paid for them. I think that's probably an uncontentious submission, but if I can give you authority for that if required.
Well, the argument was run by Mr. Simbler. Whether it was run by Mr. Byrne is a different point. But the argument was run by Mr. Simbler, so I was just looking at his skeleton argument, was that effectively this is the tort of malicious prosecution, which, like any other tort, for example, if it had been a claim in negligence, then you'd get interest on the amount of the damages.
Yeah. So
for the period between the whatever date it was when there should have been an indemnification for the loss that was suffered until the date of judgment. And here you're entitled to say, well, these claims were actually made some time ago, and they went to the Court of Appeal and came back down to the judge at first instance, and therefore there should have been an award of interest in the normal way.
Yeah. Well, I mean,
it's as simple as that, isn't it?
It's as simple as that. What I was going to do in proposing my submission is just take you to the two cases which were referred to, which are in the bundle, Saunders and Holton, to show that they are the limitations of those authorities in terms of being binding. So turning first to Saunders, which is at tab 3 of the authorities bundle. So this was a claim for fraudulent misrepresentation relating to the sale of a flat on the false basis that the buyers would have access to a roof terrace. And one of the issues in the case was whether pre-judgment interest should be awarded on damages for disappointment and inconvenience arising as a result of the defendant's fraudulent misrepresentation. £500 had been awarded first instance for the damages, and interest had been awarded from the date of claim. So Lord Justice Kerr rejected the interest claim in a judgment with which Lord Justice Nichols agreed. And you can see the start of his consideration of the issue at 1128C of the report. You see, that's a sidelining. But then if you turn to the next page, you get to where he deals with sort of the substantive reasoning. And you can see that at 1129B to H. And if I just read you a couple of passages, first passage starting at C. But in my view, this is a case in which the court should interfere with the judge's award of interest because he must have erred in principle. It's clear he took into account all of the circumstances up to the time of judgment, and indeed to some extent he looked into the future. He was quite right to do so. But on that basis, there could be no justification for awarding interest from the date of the writ. That would only be right if the plaintiffs should have had that sum in their pocket there and then, as in the case of a breach of contract. And that's contradicted by the judgment itself. And he goes on to say that therefore the judge's exercise of discretion cannot stand. And then here's some submissions on personal injury damages and the analogue with those. And he goes on at just under F on the same page. As Mr. Spearman pointed out, section 35A1 and 2 draw a distinction between awards of interest in personal injury cases and others. In personal injury cases, subsection 2 provides that interest shall be included unless the court is satisfied that there is some special reason to the contrary. As it seems to me, certainly in the present case, though without purporting to lay down any rigid rules, it is generally better to award a global sum under this head of damages without the addition of any interest. Although I might have awarded more than £500 in the case, that's not under appeal. Okay, so he obviously highlights there the substantive difference between personal injury damages and other claims, notes that it would be better to award a global sum, expressly notes that his judgment related to the case in question and that he wasn't seeking to lay down any rigid rules, and that his overall justification in the first passage was that you shouldn't be awarding interest unless the claimant should have had the money in their pocket at an earlier point. And of course, on the fact of this case, because the judge had been awarding damages, including for the inconvenience and disappointment up to the trial, that into the future wasn't justified. So that was the judgment, part of the judgment that was agreed with by Lord Justice Nichols. Lord Justice Bingham deals with the matter slightly differently, and that's on the last page of the report, 1135 D to G. And I'll just quickly read it. It starts at E. The judge's award was clearly intended to compensate the plaintiffs for the inconvenience that they had suffered throughout their occupation of the flat up to the date of trial and for disappointment during the same period. It was a single global award, modest in amount, but intended to cover the past and the future. It is somewhat analogous to an award of general damages to a defamation plaintiff for mental distress and suffering, which have never, as I think, been augmented by interest up to the date of trial. I consider this approach to be correct in principle, because in neither case can the damages realistically be seen as having accrued due to the plaintiff at a certain time in the past, and as having thereafter been wrongly withheld by him. So his conclusion is one of principle as opposed to on not laying down rigid rules. But of course, it's the judgment of Lord Justice Kerr with whom Lord Justice Nichols agreed.
Well, I mean, the point is, Lord Justice Carr, it was pronounced actually.
Sorry.
Lord Justice Carr makes the point that it would have been better to have an uplift on the amount of the damages to reflect the interest element, and that he would have been inclined to do that, but it wasn't under appeal, so it's a slightly artificial position, really. And you can see the real problem here was the judge had awarded 12.5%, which even in 1986 or whenever it was going at some, to put it bluntly. And it was accepted that that was wrong in principle. So the Court of Appeal had to do something about the interest element. But it might be thought that Lord Justice Bingham's approach, albeit in a minority, is a more conventional approach to interest on damages.
Yeah, I mean, I think the key point there is that because the judge, and the distinguishing point between that and the present case, because the judge was awarding damages up until and into the future, given that the purpose of interest is to compensate someone for not having the money in their pocket that they should have had in their pocket, that was conceptually didn't work on the particulars of that particular case. So then just turning to Holton, which is the very next tab, tab 4. This was, of course, unsurprisingly, my known friends place reliance on this because this is in the context of wrongful arrest and false imprisonment. It was decided very shortly after the Saunders case. So the Master of Rolls gave the lead judgment in this case, but it's important to note that he was allowing the appeal of the police against a ruling of the judge at first instance that the arrests had been unjustified. So effectively, the ruling of the Court of Appeal in this instance was dismissing the underlying claims. He then goes on to deal with the issue of interest in comments at the end of his judgment, which are, of course, therefore obiter, because he had effectively dismissed the underlying claims. At 13b, so 13 of the internal pagination of the judgment, and at B is where he starts talking about interest. He says, and if I would just look at each short passage D through to G. Since then, a similar division of this court has considered a similar question in deceit, Saunders and Evans, which we just looked at. It ruled, and it gives the various passages, that personal injuries claims were in a special category and the interest should not be awarded where the cause of action was deceit and the damages related to non-economic loss. The principle underlying this decision must, in my judgment, apply to general damages for wrongful arrest and false imprisonment. This will cause no injustice, since juries, when awarding damages, will no doubt take account of how long it has taken plaintiffs to establish that the arrest and imprisonment was unlawful, and of any increase in their suffering due to this delay. So just make a couple of points in relation to that. Obviously, firstly, he relies on Saunders without, and Lord Justice Bingham's judgment in Saunders without noting that actually the majority judgment was that of Lord Justice Carr, but that's a relatively minor point. Insofar as he relies on Lord Justice Bingham's analysis, which was premised on the damages for distress and inconvenience, in that case including damages and losses up until the trial date and into the future, he doesn't explain, does the Master of the Rolls, how that principle could be applicable to a claim for damages arising for example, loss of liberty, where the very nature of that claim involves an endpoint to the loss of liberty at some point in the past, when the person is released. That is the point at which time, when the person was released, they would have a right to damages, and that's something that's been accrued in the past. So that is, my submission, conceptually different to the example given in Saunders, where you've got ongoing entitlement to damages up until the trial date and beyond, and therefore it can't be said that the individual is a person who should have had their money in their pocket at an earlier point, for which they'd be entitled to interest. So my overall submission is this. Neither judgment in Saunders or Holton was binding on Mr. Justice Cheema-Grubb in the context of interest on malicious prosecution or false imprisonment cases. As matters stand, there's no current Court of Appeal authority expressly precluding an award of pre-judgment interest in a case involving damages for loss of liberty or malicious prosecution. In the alternative...
From what date do you say interest should run?
Well, there are two alternatives. We say either from the date where no evidence was offered, which is because that's the end of the restricted bail conditions, and that would have been the 11th of March 2011.
And at what rate?
Well, we could say 2%, for example.
2% over base. 2%.
So
Well,
what rate are you asking for?
Well, we put down as a suggestion, just 2% over base. Well, we've written down 2% interest rate, which was we've done that because that, I think, as my understanding, is the award that is the interest that's awarded in the context of personal injury cases. But of course,
you say that should run from 2011.
Well, there's two options. It can either run from the. I mean, we'd say yes, but there's an alternative.
Just my interpreting, remind the date in 2011.
11th of March 2011. That's from then up until the date of the hearing for Cheema-Grubb. That's well, not the hearing. Sorry, the judgment is 3,065 days.
The alternative is from the date when the claim form was.
Yeah, that's right, and that would be.
The claim form issued 2013.
Yeah, and that's
14.
One of them's 13, one of them's 14. Whose was 13?
I've got
Mr. Vian's.
I mean, I've got two case numbers. One has got HQ 13 and one's got HQ 14. That's on.
It's a difficult task, and we haven't got the claim form in the papers. But...
Yes, I apologise for that. We've got. Oh, if you look at page 14 of the appeal bundle, it's our skeleton argument with the chronology, where we've put it down. I don't know if this is agreed or not for our claim.
10/3/14.
Yeah, 10th of March 2014. Yeah, so that's agreed.
Just within the 3-year limit.
Yeah.
In so as it's sort of, yes.
Yeah.
Yeah. So just for the citizens of the court, and that would be 1,970 days. If we're just looking at, if you were awarding 2% on the longer period, that would amount to interest in the value of £10,070 for loss of liberty award and £4,531 for malicious prosecution. And if you're doing the lower thing from the date of the claim being issued, that would be loss of liberty £6,473, £42 and £2,000.
Sorry, you're going too fast, mate.
Sorry. So the larger figures for the longer period, if it was 2%, were 10,070 for loss of liberty and 4,531 56 pence for malicious prosecution. And if
so again, £10,070 plus.
No, £10,070 for loss of liberty,
yeah.
And then for the malicious prosecution element of the award,
yeah,
£4,531 56 pence.
Yeah.
And then for the if it was a shorter period of time, loss of liberty would have been £6,473 42 pence.
Yeah.
Malicious prosecution, £2,913.
£2,913.
4 pence. This is all on the premise that it was 2% if you were awarding at 2% interest. And I said I only done it as an example because ultimately it's the discretion open to the court as to what interest rate should be awarded. So if the alternative, of course, that was the point that was made by the Master of the Rolls in Holton was, well, if you're not going to, there's not going to be any injustice because the judge should then, or the jury in those instances, should uplift it.
The damages.
And yeah, but of course there's no suggestion that is a consideration that the judge has undertaken in the present case, and that was something that was expressly before her in the written submissions of Mr. Simpson, because he pointed out that was the alternative way that you could go about things.
Yeah.
So my lords, my lady, those are my submissions, both in terms of the loss of liberty award per se, and then the interest element. Unless I can assist you further.
No.
Yeah. That's very good, Mr. Limo, and you would, of course, have the right to reply.
Grateful, thank you.
Yes, now, Mr. Bear.
Ground 1, my lords, my lady, has 3 limbs to it. I propose to deal with each in turn, but as I understand it, 2 of them have effectively been abandoned, and therefore I'll be very brief. Before I do so, may I make a general point that applies to the appeal as a whole, and in an attenuated way, in fact, to the cross-appeal that we bring. And the general point is one that the court will have, I think, that the court should only interfere with an award of damages where it's plainly wrong, either because of some legal error in the approach of the judge, or because the total award was outside of the range of awards that a reasonable judge could properly award.
Well, I never liked the epithet, adding in the epithet plainly, because under the rules it's wrong. Well,
yes.
The test is whether it's wrong or not.
Under 52, that is.
Yes.
It's just wrong.
So either it's wrong. So adding the word plainly is.
Well, one sees that word creep in.
It does.
It damages appeals in particular.
And what I'm saying is it shouldn't.
No. But
I'm sure I've done it myself, but it shouldn't really. Anyway, we've got your point. The point is that the point is one has to respect the evaluation of a trial judge on what is essentially
yes, this isn't a
evaluative decision. Yeah.
It's not a reassessment of damages hearing by
it's
this.
It's not asking necessarily would we have done the same. It's whether it's answered.
No.
Right.
And which is why appeals on damages are not all that frequent.
But as you know, what Mr. Lima says is, well, she did go wrong in principle.
Yes, and I'll come to that in a moment. But the particular point is that it's even less appropriate for an appellant to seek to isolate one component of the award, here the award of damages for loss of liberty, focus on that element when the judge's judgment as a whole discloses that there were a number of elements of, if I might call them push and pull, throughout the judgment, where she maybe takes with one hand and gives with the other.
Well, that's a point that might cut both ways, mightn't it, Mr.
It may do. That's why I said that this point
does
apply.
That submission just the same. Mr. Lemmer could make the same submission against you.
Yes, and I'm ready for that. But that's why I said earlier that it applies in an attenuated way.
Yes,
my
well, I heard you use the word attenuated. I thought that's what you meant.
Yes. The court should be vigilant not to act in a way that upsets the delicate relationship between all of these elements that the judge wove by her judgment. That's reflected, I think, in the permission grant by Lord Justice Males. Cross references page 138 of the bundle. While circumstances in which this court will depart from an assessment of damages involving an evaluation of a variety of factors are limited, and then he continues. And the push and pull element that I mentioned a moment ago, the delicate interrelationship between the elements that went up to make each of the judges' awards, can be seen throughout the judgment. And with that introduction, can I turn to what was the second limb of the claimant's argument, but it's been elevated to the first, I think, only element on ground one. It was unlawful for the judge to award a lower sum for loss of liberty than that in a comparable immigration detention case, AXD. Cutting through things, that is the essence of the submission that has been made to you in writing and orally. And whilst in writing and orally, Mr. Lima accepts that awards will be fact-specific, having made that acknowledgement, he then goes on to do the very thing that the authorities caution against, namely a cross-comparison with another first instance damages award. And with respect, we can see the error of approach in the skeleton argument. It's paragraph 13 of Mr. Lima's skeleton argument, which is in the appeal bundle at tab 3 and is at page 19. So page 19, appeal bundle. And you'll see the appellant sets out his suggested approach. It's contended that a regard should be had to awards for similar periods of detention, underlining, in immigration detention cases. In the event there is a disparity between the awards made, that disparity needs to be justified. And we say this is where the appellant goes wrong. He uses the phrase similar periods as the measure for comparison. The reasons why that approach are wrong are manifest. And if I can spend a couple of minutes just going back to the basic principle here, by looking at Thompson and Sue itself. That's Authorities Bundle, Volume 1, to see what damages are in fact being awarded for. So Thompson and Sue, Authorities Volume 1, tab 5. I'm not going to take the court gently into the case because I'm going to assume familiarity with it, given its centrality to the appeal. If we can look, please, at page 515A, where we're in the midst of Lord Wolfe, the Master of the Rolls, principles. And at 3, this is giving the judgment of the court, consisting of Lord Justice Old and Sir Brian Neal. The jury should be told that basic damages will depend on the circumstances and the degree of harm suffered by the plaintiff. So that's the starting point, the circumstances and degree of harm suffered by the plaintiff. Not on or only on the length of detention. And then one can see a similar point picked up again by Lord Wolfe in the next authority with which he was concerned, at tab 8 of this bundle, please, which is ex parte Evans. And can I invite the court's attention, please, to page 1060. In his judgment, just before Lord Justice Roche's judgment begins, at F to G, 1060 F to G, the paragraph beginning with "we accept that an award."
Yeah.
And the passage that I particularly highlight is, this is a global figure. We recognise that it's possible to work out a daily, weekly or monthly figure from this amount for the approximately 2 months extra imprisonment of this case, but we discourage such an exercise. No two cases are the same. The shorter the period, the larger can be the pro rata rate. The longer the period, the lower the pro rata rate. The length of sentence lawfully imposed is clearly similarly significant. The fact that the appellant was prepared to risk postponing her release date by committing disciplinary offences is also relevant. And so it's not a linear relationship, it's not a straight line graph. It has very much a pronounced curve on it. This point is a fact very well made, with respect, by Mr. Justice J in AXD himself. And in addition to the passages that my lady has already identified, can I show the court a couple more? This is tab 26 of this bundle. And can I invite you to turn up paragraph 27 onwards? The court will see that Mr. Justice J, between 27 and 33, conducts a comparatively brief survey of the authorities. I'm not going to ask the court to read those, you can just see that that's what he's doing. But then in 34, he makes a really important point, which I would invite you to read, and if it takes the court to mark, and maybe even adopt. Of course, there's a deep irony in the appellant seeking to rely on AXD as the comparator to conduct the very exercise that Mr. Justice J cautioned against. The point is already made rather more pithily at paragraph 41, which Lady Justice Laing has already picked up, first sentence. I don't know whether it will be of any interest to the court, but in a different context, it has been said that this is a barely respectable intellectual exercise.
What is a barely respectable intellectual?
The assessment of damages in loss of liberty cases.
You mean by comparison to other cases?
Yes.
Well, who said that?
We can turn it up.
Yeah.
It's at tab 15.
Tab 15.
Yes.
Yeah.
Sorry, that's a rogue reference. I'll be there in a second. tab 14. So this is a judgment of Lord Justice Latham and Mrs. Justice Swift, in which a challenge was brought to the award of an independent assessor. And you remember the independent assessors assess damages for miscarriages of justice detention cases. In this case, it was Lord Brennan QC. And if you see on the third page, this is an extract. It's slightly difficult to read, but it's 2 paragraph 6. Does the court have that in the middle of the whole punches?
Yes.
Yeah.
And Lord Justice Latham is quoting Lord Brennan QC's judgment that was appealed. And Lord Brennan QC said the Court of Appeal described the assessment of damages, that's in this context of loss of liberty cases, as highly fact-sensitive, imprecise and artificial. It is a barely respectable intellectual exercise. So that's a citation from another case that we don't have. Well, he's talking about the exercise as a whole there.
One doesn't like to talk of plucking a figure out of the air, and indeed the court shouldn't really do that, but they're there. I mean, a broad approach is sometimes inevitable. But what is not inevitable is the factors that need to be taken into account.
No, the principle.
How long, what circumstances, all that, yes.
Yes, I mean, there are other metaphors of sort of hanging a piece of seaweed out of the window.
It's a quotation, isn't it, from the Court of Appeal in O'Brien?
It is,
which if you need a reference, which I think we've got, haven't we? We've only got the House of Lords case.
You've got both sides of it. You've got first instance and House of Lords. If
but
you would
not
like
the Court of Appeal.
No, if you'd like the reference, no.
Yeah.
That's where it's from, though.
That's where it's from, the Court of Appeal. Now there are a range of reasons why the type of cross comparison that the appellant engages in is particularly inapposite, even dangerous, when one is comparing immigration detention awards with detention in the criminal justice context. Most of them have been traversed already, but if I can list them out from the respondent's perspective, they are. First, in the immigration context, a feature which often enhances the award is that the claimant is fearful of being returned to the country of origin or another country, in either of which there will be persecution. The cross-reference for that is AXD at 39, where that point is recognised. The second point is that in the immigration context, a feature which is often said to enhance the award is that there's no clear and settled date on which the detention is fixed to end. Which causes uncertainty and unpredictability, which causes additional distress and anxiety. And that's to be compared in the criminal context, where a person on remand will at least know their trial date, and a convicted person will know their earliest release date.
Well, not in a life sentence, they won't.
No, they'll know their earliest release date.
Well, they may not be, but they don't know that they'll be released when the minimum term's expired.
No, they won't. But there's much more certainty involved.
There's no entitlement, as in a fixed term.
I suppose they'd know a date upon which at least the
possibility
arises considered by the parole board.
Yes.
So
yes,
when
the case
element of certainty.
Yes.
If it is certainty.
Well, the informed immigrant in detention will know that Harjil Singh principles apply and that there will be an end date sooner or later.
He will also know how the Home Office sometimes doesn't quite get it right with Harjil Singh, the Harjil Singh principle.
You're right there, Mr. Bear. Yeah.
And therefore will be caused unpredictability by the application of the Harjil Singh.
Well, whether it's right or wrong, you say an element that is considered in these cases is that element of uncertainty.
Yes, the third point is that in the criminal context, the issue of loss of reputation and the impact of previous criminality are far likely to be more important features. Indeed, in the authorities concerning detention in the criminal context, substantial discounts have been made reflective of a claimant's past antecedent history. I'll list them without going to the authorities in the interest of time. Wilkinson, tab 6, it seems a 33% deduction was made on account of past criminal history. Clark, tab 7, 50% discount. O'Brien, tab 10, deductions of 25 and 20% were made. Whereas in the immigration context, discount has not always been consistently applied, for reasons which I've got to say are rather obscure and perhaps may not be, need to be addressed by the court here. But the fact of the matter is, it's another reason to treat those authorities with caution. That sometimes past criminality discount is applied and sometimes it's
well,
not.
If what you're dealing with is unlawful detention of somebody who is purported to be being deported as a foreign criminal, as some of these cases are, then it's a bit difficult to see why logically the discount shouldn't be applied in exactly the same way.
But it hasn't been.
No,
is my point. No, because necessarily a condition precedent to them being in the category of a foreign national prisoner is that they've committed an offence.
Yeah.
Any others to your list?
No, but here...
Is there not one big picture point? Namely that awards in immigration detention cases tend to be global awards. And so if you're trying to use them as a comparator for a case such as this, it can be very difficult to know what element of an immigration detention award was intended to reflect the loss of liberty and what element was intended to reflect the distress.
Yes, I mean, I make that point in a moment, but it could equally be made now. There's no strict in the way that Mrs. Justice Cheema-Grubb did. And in fact, my Lord mentioned, I think in argument earlier, that in these cases, the criminal justice context cases, one sees a separate award commonly. In fact, one doesn't. This case is unusual, where Mrs. Justice Cheema-Grubb's award is unusual in that a separate divisible amount was awarded for distress and anxiety on the one hand and loss of liberty on the other. One does not see that in any of the other authorities. But the point is a good one, my Lord. And in due course, when I come to my second submission on this, when that point is borne in mind, one will in fact see that there is no disparity between this case and AXD at all.
Yes.
The awards are within £1,000 of each other.
Do we know whether AXD was a foreign national prisoner or not? I mean, I wonder whether he was, because he was initially detained at HMP Woodhill, see paragraph 5 of the judgment.
Yes, I'm not sure that we... I think we can find out.
I mean, you'd know, you'd presumably find out from the judgment.
We can look at the liability judgment, yes.
Yeah.
Which I read the night before last, but I can't remember.
But I'm not sure Mr. Justice, I mean, I'd have to look at it again, I'm not sure Mr. Justice J makes any discount from the damages to reflect that if indeed he was an FNP.
That I can agree with. He certainly doesn't make, on the face of it, a past criminality discount. Here the judge was dealing with a claimant, Mr. Rees, who had a very serious criminal conviction, perverting the course of justice, for which he had proximately to the arrest and the charge for the murder offence served a sentence of imprisonment of 7 years. Mrs. Justice Cheema-Grubb makes a mistake in paragraph 16 of her judgment in saying it was 6 years imprisonment. It was 7 years imprisonment. It was 6 years at first instance, increased to 7 years by the Court of Appeal Criminal Division.
When was the halfway mark, the sentence?
That I don't know, but I can come back to you.
But the total sentence was 7 years?
Yes, it was.
So what he actually served would have been less?
Yes.
Sentence, so sentence.
I think one can pick up from Mr. Justice Mitting's judgment somewhere, the detail of that.
Yes, that it was a 7-year sentence in imprisonment. And my last point on this argument is that the vice of the cross comparison that Mr. Lima engages in is compounded. It's made much, much worse when the comparison is with a single case, namely AXD. He compares his case with the first instance decision of AXD. I don't want to be too critical of Mr. Lima in doing so. The AXD cross-comparison is an approach frequently adopted by claimant counsel, certainly in the immigration field. So my first and principal submission is that the court shouldn't entertain the exercise that it's invited to undertake. It's not permissible as a matter of principle. But my second submission is, in fact, on analysis, there's no disparity whatsoever. The claimant in AXD was awarded £80,000, which uprated for inflation to the date of Mrs. Justice Cheema-Grubb's judgment was £86,000. If the court looks in the appeal bundle, quantum submissions in tab 10, and looks at pages 170 A, B and C, which should be an insert, 117 A, B and C. Yeah. Mr. Johnson diligently included all of the awards in all of the cases mentioned.
Well, I'll bet Miss Fentham did all the hard work.
I was about to say it's probably very unlikely to be Mr. Johnson.
Okay, anyway, yeah. Yes, so your point is?
You can see 117A, third box from the bottom, the updated amount for AXD was £86,290 at the date of the case coming before the judge in the lower court. The appellant in this court insists that he was only awarded £60,000. But that's entirely to ignore the way in which the judge approached the issue of basic damages, which was to split up the damages relating to the consequences of being wrongly accused of a crime and imprisoned on remand.
I think it sounds like a Skype call on someone. The laptop.
I think that's where the usher was sitting.
That's where the usher was sitting. Could we have that taken away? Thank you.
It's a new variant on the mobile phone going off in court.
Well, there's no one we can send to prison for contempt of court, is there? So, all right. That's all right. Thank you very much.
I'll let her know when she's
Thank you very much. Thank you.
Thank you. I was making the point that the judge made the split between, on the one hand, the distress of the accusation and the distress of being locked up, and on the other, the true loss of liberty award, i.e. having your freedom of movement constrained, awarding £27,000 for the former and £60,000 for the latter. Whereas in AXD and many other cases, including all of the immigration detention cases, a global award is made in this respect. But this court needs to look at the global award. And so putting it another way, the awards in the immigration cases, and most of the false imprisonment and malicious prosecution cases too, do not distinguish between an award for distress, anxiety and fear caused by being detained and possibly being removed to a country of persecution, and the loss of liberty itself. That makes comparison with AXD particularly hard when one doesn't know what Mr. Justice J attributed in his mind to the elements of aggravation that he found to have existed. Who's to say that if you strip those out, his basic loss of liberty award wouldn't have come down to £60,000? My third submission is that...
What you can say is Mr. Justice J has certainly highlighted some particular aggravating factors in the case of AXD.
Yes, including...
For example, the persecution in prison and that sort of thing.
Yes, being physically and verbally abused
yes.
on the account of sexuality in prison. Yeah. My third submission builds on what my Lord has just said. There is no true comparison between this case and AXD. The particular features were the conditions of detention were poor in AXD. See paragraph 6 of the judgment, reflected in the award at paragraph 40 of the judgment. Maybe if we just turn that up to see it. AXD at tab 26. Paragraph 6. When AXD was at Woodhill, he was locked in his cell for 21 hours a day with only 30 minutes of fresh air. Although he was a poor witness, the judge accepted his evidence. And then at 40, when coming to the award, for the business end of the judgment, in my judgment, it's relevant that the claimant was kept in his cell for 21 hours a day at Woodhill, and the regime at the Immigration Detention Centre was less positive. Paragraphs 7 and 8 of the judgment, the claimant was verbally and physically abused for being a gay man. That's also reflected in paragraph 40 of the judgment. Second sentence, it's also relevant he experienced personal difficulties on account of his sexual orientation at both institutions. But the better view is that these improved some way through. Para 39, he accepted the point, the learned judge, that the claimant must have been fearful of being returned to Somalia. This enhances his basic award to some limited extent. But the enhancement was modest because the claimant's insight wasn't great. He suffered from a personality disorder. So looking at the case generally, building on a point I made earlier, it's not apparent from the decision as a whole what Mr. Justice J discounted, if anything, on account of the claimant's past criminality. And it's certainly clear from the liability judgment that he had many previous convictions.
In Mr. Justice J's case?
Yes. Yes, the liability judgment.
So was he detained pending deportation? Do we know that?
Yes.
So it's an FMP case?
Yeah. So if he was detained pending deportation, he would immediately, before his period of immigration detention, have been serving a sentence of imprisonment.
That's right.
I mean, very likely, anyway.
And so against that background, the type of analysis undertaken by the appellant, in particular in paragraph 15 of his skeleton argument, it is with respect not of assistance either to the appellant or to the court. I mean, if we just take one example, if you could turn up paragraph 15 of the appellant's skeleton argument, in this minute cross comparison, and look at 15b. It says that the claimant, our appellant, was detained within the prison estate throughout. That's correct. Including 5 months as a Category A prisoner. That's also correct. And then it said, whereas AXD was only detained in the prison estate for 4 months. That's incorrect. If you look at AXD, right back to the beginning, paragraph 5, the claimant was detained at Woodhill Prison, this is paragraph 5 of AXD, between November 2011 and the 14th of May 2014. Now, not all of that period was unlawful. It's only the period between November 2011 and the 31st of March 2013 that was unlawful. But the entirety of that period was whilst he was at...
So the period between November 2011...
Yes, sorry, was not unlawful.
Yeah.
So the unlawful detention begins on the 1st of April 2013.
Yeah, so it's just over a year.
It's 1 year, 1.5 months.
Yeah.
Not 4 months.
Just as a matter of detail, his previous convictions are actually set out by Mr. Pepperell in his judgment in Mohammed. Paragraph 36, AXD had previous convictions for unlawful wounding, sexual assault of a child under 13 and criminal damage, and had been sentenced to various terms of imprisonment, notably 16 months for the wounding and 21 months for the sexual offence.
Yes, thank you.
But as you said, it's unclear whether Mr. Justice J discounted the amount of the award for those previous convictions, but certainly in Mohammed, the judge did discount because he identifies it as an important factor that Mr. Mohammed had been in and out of prison.
Yes. I mean, it appears on the face of Mr. Justice J's judgment that he... it's certainly not suggested that he was invited to make a crime discount, criminality discount.
No.
My fourth submission, this might be said to be a jury point, but I'll make it nonetheless and see where it goes, is in a recent decision of Mr. Justice J last week, he cited not only his own decision in AXD, but that of Mrs. Justice Cheema-Grubb in the instant case in arriving at an award, without suggesting that Mrs. Justice Cheema-Grubb's award was in any way out of line.
Well, if we haven't got the transcript of the
No, we have. It's in the bundle.
The judgments in the that judgment's in the authorities fund.
Yes, we've put it in.
Whereabouts is it? Sorry.
So tab 35.
Didn't look at this, I'm afraid.
No, you'll see that it was decided on the 1st of December.
Is this a unlawful?
It's an unlawful detention case, but in very odd circumstances. It's a claim against a barrister for negligent representation.
Right.
You can see from paragraph 1 that this was a claim for professional negligence brought by a man who had been convicted of rape and sentenced to 6 years imprisonment, but whose conviction was subsequently quashed and whose retrial resulted in his acquittal. He alleged negligent representation against his counsel. In fact, the bulk of the judgment is taken up with Mr. Justice J dismissing the claim on the facts. Yes. But he turns, in the alternative, to quantum at paragraph 303 and following. When you're reading this, it would be perhaps helpful to have in mind that the length of detention in this case was 20 months.
But the basic case was the barrister had negligently represented him, and
yes.
as a result of that he was convicted, and until the conviction was set aside,
yes.
he'd spent 20 months in prison.
Yes.
And he was trying to attribute that to her alleged negligence in her conduct of his case. Is that it?
That's the long and the short of it. Claim dismissed on the facts, but judgment given on quantum in any event.
Very unusual, very unusual.
That's why I said it arises in unusual circumstances. But you'll see in paragraph 304 that Mr. Justice J said he would have awarded £65,000 for loss of liberty in reliance on, amongst other cases, AXD and Rees for a period just shy of 20 months imprisonment. Not suggesting that Mrs. Justice Cheema-Grubb's award was in any way out of line with his own in the previous case. As I say, it's it might be said to be a jury point, particularly as this was overturned. And my last submission, my fifth submission on this first limb of the appeal, is that there are plenty of other first instance and appeal decisions where awards were made that justify and support the award made by the judge in this case. Miss Bentham set them out in paragraphs 19A to D and 20A to F of her skeleton argument. I'm not going to repeat them now, in part because it involves the very exercise that I've cautioned against, and in part because you've got the necessary material in the skeleton argument and all of the authorities that support them.
Well, reference these things are usually to give the court the broad parameters within which judges normally work. That tends to be as far as it goes. And that's, of course, why we have the guidelines, you know, the first injury guidelines and all that as well.
Yes.
Yeah.
So those are my submissions on the principal points pursued by Mr. Lima this morning. Can I just briefly address, in deference to the judge, the two other grounds of appeal, where I think it's said by Mr. Lima that she made a mistake, but it doesn't matter. And
The cross-check point.
Yes, the cross-check point is the first of them.
Well, you would say what's wrong with doing a cross-check?
Yes, it's...
Well, do you need to say any more than that?
No.
Right, so third point?
Up-to-date cross-check, perfectly legitimate.
Yes, I mean, the fallacy of the logic was that the judge only looked at Thompson and Sue, then reached a damages award, and then did a cross-check.
It's not a double counting point at all.
It's not double counting.
No, I think Mr. Lima really accepts that.
Yeah.
Right.
Right.
And similarly, I won't address the court on the third limb.
The detention post-charge.
Yes, I mean, that's very worst is the wrong use of a word.
Well, not only that, but the paragraph you were taking to was one where there was an express concession on behalf of the claimant.
Yes, I mean,
so if there was an error, then it seems to have been induced by claimant's counsel. But as I understand it, it accepted there wasn't an error.
The detention was lawful pre-charge.
Yes.
Yeah.
It ceased to be lawful after charge.
Yes.
But the big picture point, though, was what mattered was there had been a period of initial lawful detention.
Yes.
At what stage it occurred is really not. I think Mr. Lima really accepts that.
The judge was right to say there wasn't an element of shock here because it was lawful detention.
The slam of the prison doors, which sometimes is described as.
Obviously a very important matter, especially if people are wrongly accused.
Yes, or where they're arrested from the street and there's ignominy caused because of that, because other people see it. The shock of being taken to a police station for the first time, that kind of matter. But the short point is the judge knew that this appellant hadn't walked into the police station and was immediately charged.
That's right. Yeah.
She was a very experienced criminal practitioner before coming to the bench.
Absolutely.
And knew that people were arrested, then they're interviewed, and then they're charged.
No, and it's rather unfortunate sometimes in the popular press, it's not sufficiently clear to people there's a very great difference between being arrested on the one hand and being charged on the other.
Yes.
A lot of people don't understand that. Right.
Can I deal with the interest?
Interest, yes. Now there's some interesting points perhaps, interesting points here perhaps.
Yes, but ultimately I think I would submit that the appellant's case on this is wrong in law and against the weight not only of the authorities that you've been shown, but the academic commentary, which I'm just going to show you very shortly on this very point in McGregor.
Right.
So the starting point is that under Section 35A of the Act, the award is entirely at the judge's discretion. And it follows that the appellant's task is a difficult one because, again, he must show the decision not to award interest is one.
It's perhaps not quite as difficult as it might otherwise seem because the judge simply didn't deal with the point and gave no reasons,
Well,
it might be said. So that being said, that would be a basis in which the appellate court could interfere.
I thought one may say that. What she did say
I'm saying it.
my response is what she did say is, I'm only going to award interest after judgment. One can see that in her judgment.
She says that.
At 54. And that's very much like the cost cases, where one expresses the outcome, but doesn't have to go into the reasons for the rejection of the counterposition.
It is striking that this is a point that was actually being run by counsel for the other claimant, not in fact, as I understand it, by Mr.
By this appellant.
And presumably the judge's judgment, because she took slightly over 2 months to produce the judgment, must have been sent out in draft. And one would have expected somebody to have picked up this point and said, well, you haven't dealt with interest.
Yes, that wasn't the English Emery Reinbold's expectation that that's what occurs.
It's difficult to think that Mr. Byrne wouldn't have been, as it were, adopting Mr. Simblett on interest, isn't it? I mean, if the point is good for Mr. Simblett, it's good for Mr. Byrne, isn't it?
Yes, it was pleaded in the claim form.
It was.
It was.
Yeah,
Do you have a copy of the claim form?
I don't. I've got a copy of the particulars.
Or perhaps in due course you can get into us.
So it was pleaded.
Interest was pleaded.
It was
claim
pleaded.
for interest.
I mean, it was pleaded in the prayer and the particulars.
Is the starting date for interest? Is it just pleaded in general?
No, I mean the plea is, and of course this was at a time. It's to be remembered. The court may not have picked this detail up. It's in a prayer which just says, and the claimant's claim 3, interest pursuant to Section 35A of the Senior Courts Act 1981 in the way that some people plead. This was pleaded at a time when there was a personal injury claim. The court may have picked up the fact that a personal injury claim was struck out by the master and not revived.
But this would be a claim for interest under Section 35A anyway.
It would.
Right. Do you think Mr. Venton may be trying to pass you something, Mr. Beer?
Yes, it's slightly difficult in these circumstances.
Well, that's why I mentioned it.
Thank you very much.
We had this problem yesterday.
Yes, I can show you the claim form, thank you.
Does the claim form...
doesn't include interest. Particulars of claim does.
Yeah.
Do we have the particulars of claim in the bundle?
No.
But Theodore, can we at the conclusion of saying, can someone send to the court 3 copies of the claim form, particulars of claim? You've got access to them yourself, have you?
By instructing solicitors.
Well, Ms. Bentham, could you also then send it to Ms. Lima as well, if whoever's got it?
Yes. Thank you.
Yes. Right.
But a decision that interest should not be awarded from the date of the issue of the claim, on any view, the interest, even in personal injury claims, doesn't arise from the date of the accident. It arises from the date of the claim form. So the very ambitious claim made earlier that this entitlement should arise from the date of the end date of the imprisonment is incorrect. But a decision that interest should not be awarded from the date of issue of the claim form on the damages for loss of liberty is entirely in accordance with the authorities that you have been shown, and as I've said, on McGregor. I'm going to take the court in a moment to the 2 authorities.
But it's different from Holton. Well, maybe it's different from Holton, because at Holton you don't know where you stand until the jury have pronounced. And then it can be taken that the jury in its award will have factored in a figure up to the date of their award. That's not quite this case, is it?
No, but that's not the true policy reason, which I think has been isolated essentially. There are 2 reasons I would submit that justify this approach in this category of case. One identified by Lord Bingham in Saunders, and the second, as we'll see in a moment, identified by the authors in McGregor. I wonder whether we can hand up 3 copies. I've given a copy to Mr. Lima of McGregor.
Have you given a copy to Ms. Lima?
Yes.
Oh, yeah, right.
Thank you. This is from the current edition of McGregor.
Yeah.
And we've given you the surrounding passages as well, rather than plucking only the relevant paragraph out. And you'll see the way that the authors treat interest. The whole of this chapter is to do with the awarding of interest. They deal with it tort by tort, with subsection 5 dealing with torts affecting land, 6 dealing with torts affecting the person, which is subdivided between personal injury awards and wrongful death awards. And so if we can go if you perhaps read the citation from Cookson and Knowles just above 1952. I'm afraid this will involve a little bit of reading for the court itself.
Sorry, where from?
The citation from Cookson and Knowles just above 1952.
Yeah.
Yes.
And ending 1953, fortunately the Court of Appeal has now had the good sense to refuse to award any interest on the damages for non-pecuniary loss in an action for deceit, and the cross-reference is there too.
So whereabouts here?
19... The end of 1953, the last couple of sentences, beginning with fortunately, the Court of Appeal has now had the good sense to refuse to award any interest on damages for non-pecuniary loss in an action of deceit, and the cross-reference is to Saunders and Edwards. It will be wise to do with the same in personal injury and also wrongful death. You'll see.
But how does that fit within the open-ended nature of Section 35A?
Well, the authors are approaching this on a principled basis, namely that the purpose of interest is to compensate somebody for money that they have been kept out of, not to make an award a replacement for other money that they were due because some harm, some damage has been done to them.
Well, I certainly don't understand the suggestion of the Landletters that it'd be wise and appropriate to do the same with personal injury and also wrongful death. Thought personal injury had been dealt with by statute.
Yes, I take that.
Look at all of it, doesn't one, Mr. Beer? One has to look at the whole passage the whole of this passage if you're relying on it, rather than picking the plums and leaving the duff behind. Because Cookson and Knowles was not followed by the House of Lords in Pickett.
Yes.
And then that was again followed by the House of Lords in Wrighton British Railways Board.
Yes.
Although the figures that were adopted were, I think, in Wright, which is where the 2% figure comes from.
It is.
And that's what McGregor, this must be Mr. McGregor himself, I think, this text, because these cases are all quite elderly, but Mr. McGregor
it has his style too.
Yes, precisely.
Harvey McGregor's style.
It's very much so, yes.
Reflects an uneasiness at making any award at all. That's the point about 2%.
Yes.
And then he says, well, fortunately the Court of Appeal has put the kibosh on this in
elsewhere in decease. Yes, I hope I wasn't picking just a plug.
No, I wasn't. I
was picking up that passage from Cookson to show that in fact it was disapproved in Pickett and then in Wright.
I'm so sorry, but is the statement there cited from Cookson and Knowles with regard, in effect, to interest? Is that law, or has it not been accepted in the House of Lords?
That's not been accepted in the House of Lords. In Pickett, as approved by.
So I'm sorry. What are you extracting? What principle do you extract from McGregor on damages?
Okay, this was a run-up to what is said, because it's only by reading this that one can see the context for what McGregor says in 1954 and following. So he there turns to the torts with which we are concerned.
Yes.
Torts affecting the person. Can I invite you to read 1954?
Yeah.
And then maybe skip over 55, if you haven't already, and then read the whole of 56, please.
In the present case, did Mrs. Justice Cheema-Grubb spell out that she was calculating her award of damages as at the date of judgment?
Yes.
Just show us where, please.
I think well, I think I've got that from the fact that all of the figures she gave are uprated for inflation by reference to the respondent's table.
She doesn't. I don't think she does actually.
So spell out. I was wrong to say yes, but the figures that she has used are.
So it's implicit in her judgment, you would say, that she's calculated a damages award by reference to the date of judgment.
I think implicit is slightly too weak a phrase, perhaps. It's expressed because she has used such figures, but she hasn't.
Just take us to the passages, please.
And but in terms hasn't said that she's doing so.
This page, paragraph 54, isn't it?
And 55.
And you say when she says at 56, interest on the date of this judgment, that is to be taken as confirming that previous figures were calculated as at the date of the judgment.
I don't think I can go that far in saying that. What I can say
it's consistent with it.
It is, yes. And the point to bear in mind is that all of the figures, including the Thompson and Sue starting point, which was then 22 years out of date, had all been uprated themselves.
Well, I suppose you could say, given that she conducted the personal injury cross-check, she must have been looking at it in terms of today's date, or 2019 rather than some earlier date.
Yes.
Given the age of the case.
Yes.
This was about wrongful detention in 2008 to 2010.
Yes. But the claimants and this appellant have already, I won't use the word benefited from because that's too harsh a use of language, but the fact that their damages awards are being made in 2019 and the cases on which they are based have themselves been uprated for inflation, past the point at which they issued their claim form in 2014, has already been brought into account. If interest was awarded again in respect of the period between 2014 and 2019, there would be overcompensation, there would be double recovery. And that's because, as McGregor had said, the uprating for inflation takes into account the interest rate. That's in part inflation is based on, or how it's calculated.
Well, that in a sense is what Lord Denning was saying in Cookson and Knowles, of course.
In one sense, it is, yes.
Well, it is. It's exactly what he was saying, I think. But on the other hand, the House of Lords doesn't seem to like that very much.
So really the points...
I haven't looked at Cookson and Knowles in years. Anyway.
No.
Better go back to it.
Mm-hmm.
Right. But it doesn't really need to come back to the authorities, Mr. McGregor. What you're saying is, looking at this judgment, she has calculated damages as at 2019.
Yes.
And therefore it'd be double recovery to award interest for the preceding period.
Yes, the preceding 5 years from the issue of the claim form. And this is allied to what Lord Bingham said in Saunders, where these kind of cases for non-pecuniary loss are not where the claimant has been kept out of a sum of money at the date of the suffering of the loss.
But if that's right, you can see the point in McGregor, because in a personal injury case, that would be the same, wouldn't it? You would assess your damages by reference to modern guidelines, but yet you have a discretion to award interest from the claim form.
Yes, I take the point.
But which doesn't seem consistent with your argument. So what makes a false imprisonment and malicious prosecution so different in principle from personal injury? Do you say statute?
Well, the deal, that's one difference, that it has been...
But what does in principle? I mean, you can see in that case why McGregor argues it is. It wants it all to be coherent whole.
Yes, but that's no longer possible in the light of the...
But yet the authorities do seem to distinguish between pecuniary damage and non-pecuniary
Yes, I mean, that's essentially the thread that's running through my argument. The authorities distinguish between pecuniary and non-pecuniary loss.
Because the point is, if you're claiming a particular sum of money, it will have lost its value between the date when you were deprived of it or should have had it. Whereas the damages for non-pecuniary value because they're assessed at the date of trial.
I missed the last half of that sentence, I'm sorry.
The damages for non-pecuniary loss don't lose their value in the same way, and you're not kept out of them precisely because they're assessed at the date of trial.
Yes. Bearing in mind the time, can I turn to the cross appeal, please?
Yeah. Well, the first point you've got to deal with, how can you seek to appeal when the award was a global award against all three of the claimants and the other two are not party to this appeal?
Because it's perfectly open to the court to say that the appropriate award of damages by way of exemplary damages here was X, say £90,000, and that fell to be divided equally as the parties agree and as the judge awarded as between all three claimants. The fact that the other two...
I don't follow. I'm sorry. Repeat that again in simple English, please.
Yes, I'm sorry. It was accepted by all of the parties below, and the judge so ordered, that the award of exemplary damages, because it's punishment, should be a single sum. You reach a single sum first.
Right, which she assessed as 150,000.
Yes, and then one divides that by the number of claimants equally, which resulted in them receiving an award of £50,000 each. Here, if the court is satisfied that that global award was incorrect, was wrong, and should have been, for example, I pick an example, £90,000, then the division that all the parties and the judge are agreed upon by three still applies, that each of the claimants ought to have received £30,000 each.
But that involves reducing the damages of two people who aren't before the court.
No, it doesn't, because there's no appeal before the court on their damages awards. Their damages awards will remain.
So although they shouldn't have got this element of 50,000, it stands?
Yes.
So why haven't you brought them in on this appeal?
Even though they might.
Well, they may...
they may, quite apart from the money, they may want the bright line figure of £50,000 they can as vindication.
But
they're affected by this argument, aren't they?
No, their proprietary interests are not affected by it at all. The Commissioner has taken a view as to the best use of public funds, as to whether or not to seek to appeal an exemplary damages award against two other men who are not challenging their awards, as against this appellant who is, and is before the court in any event. The Commissioner is not seeking to recoup any money from the other two claimants, having taken that view. This appellant who's brought the issue of damages before the court is in a different position. And so if the court finds that the judge ought to not to have awarded £150,000, it means that they're not due to repay money in any way, and their position is not thereby prejudiced in that way. And the reason why I earlier said that the general point that I made as to this court's approach to appeals on damages awards is attenuated somewhat in the case of this cross appeal is that we say the judge made a real error of principle.
So just think of it, so if your substantive arguments are right,
yes,
you commit to not then seeking to appeal out of time with regard to the other two.
Yes.
But we need that assurance from you, don't we? Because otherwise arguments will run, if you're right. The court has decided, and after you've had an undeserved windfall.
Yes.
We'd have to be able to record
an undertaking on the face of the order.
You'd have to give an assurance. Undertaking or assurance probably would be enough, but that you would not pursue them.
Yes. Yes, that's exactly the basis on which the Commissioner has approached this, not by some error or mistake.
So why did the judge go wrong?
The correct approach to the assessment of exemplary damages is to aggregate the total awards of basic and aggravated damages to all claimants. Step one.
Sorry, I was writing a previous note. So could you say it again? Sorry. Step one.
Correct approach is to aggregate the total, add up the total awards of basic and aggravated damages to all claimants. Step one.
Yeah.
Determine whether payment of that total sum amounts to sufficient punishment for the wrongdoer's conduct. Step two. If, but only if, it does not amount to sufficient punishment, add a sum to that total so as to sufficiently punish the wrongdoer. Step three. Then step four, divide that additional sum between all claimants. The authorities for that approach are Riches and the Times, News Group newspapers, which is in the authorities bundle at tab 2. And again, in the interest of time, rather than walking the court into the case, can we just go straight to the relevant passage in Lord Justice Parker's judgment? It's at page 288. Between the heading punitive damages, where there are several plaintiffs, and the bottom of that paragraph ending between F and G. Can I invite you to read that passage, please?
Yes. Very clear.
Yes, if it was needed, that's endorsed in Lumber, a case with which my Lord Justice Davis is familiar.
Yes, we're interested, so
yes.
We're all familiar with Lumber.
But in particular, Lord Justice Davis.
All right, don't rub it in, Mister.
Tab 20. At paragraph 167.
167.
Yeah.
This case had so many points in it, didn't it?
It's a smorgasbord of authorities.
It had so many points in it. It's quite remarkable. Paragraph 167.
Mr. Johnson used to say that you can find support for any proposition in law if you look in Lumber hard enough.
Right. Has it got anything on interest by any?
I think that might be the exception.
All right.
Okay.
Other than there's no suggestion that the court would have awarded interest.
No, but obviously authority on damages amongst other things, for sure.
It is.
Yes.
It's just adoption by
Paragraph 167.
Lord Dyson of the approach in multiple claimants of Lord Justice Parker in Riches. There's probably no need to read it. It was more from a note. Because Riches is a very old case. So I think that's the approach, my lord.
Approves it, Riches, yeah. Yes?
Although this judge, Mrs. Justice Cheema-Grubb, did make one award and then divided equally between three claimants, 150 divided by 3, she failed to apply important elements of the approach that I've just set out. In particular, the award of £150,000 that she made substantially exceeded the amount that was said to be the absolute maximum in Thompson and Sue of £50,000 for the case of the utmost seriousness involving a superintendent directly, which uprated for inflation meant that at the date of judgment, £90,000 absolute maximum.
That upgrades to what?
90,000.
But in Thompson, were they talking about an individual figure, or were they talking about a global figure?
They don't differentiate.
Because here, they got £50,000 each.
Yes, they did. And an error that the judge may have made is thinking that the £50,000
was for an individual. So your submission is that Thompson is intended only to apply to the global figure,
correct, irrespective of the
how
numbers.
many people.
Yes.
But also it could be £50,000 in an individual case?
It could be, yes.
Seems a little... Is that principle?
Well, I think I've got to accept that if a wrongdoer's tortious conduct affects more than one person, that might make punishment more worthy and in a greater sum. That doesn't affect the Thompson top end of the absolute maximum.
But let's just think this through. I'm asking quite. Supposing in this case, Mr. Rees brought his claim first, separately, and got his award and got £50,000 exemplary damages. Under Thompson, you couldn't challenge that. Yeah? Yes?
In theory, yes.
In theory. But then supposing subsequently, by separate proceedings, the two viands being proceedings, on your argument, they'd be precluded from getting any exemplary damages.
Well, there are a number of ways of that vice is addressed by the courts. In particular, that identified in Lumber, where before making an award of exemplary damages, the court must be satisfied that all potential claimants have surfaced and are in this action. So the point in Lumber was the lower courts declined to make an award of exemplary damages because the class of claimant was unsettled. Well, it wasn't just at large, it was unsettled.
Because this was all the people who were detained pursuant to the unpublished policy that conflicted with the published policy.
Yes.
Yeah.
But the difficulty with this argument is that the Court of Appeal doesn't address at all the position in relation to multiple claimants, because there's only one claimant in Thompson. So on one view, the 50,000 that's referred to as an absolute maximum is 50,000 for one claimant. Known constat that if there are three claimants, it's not 150,000. Well, which seems to have been the judge's thinking, although she doesn't, you're quite right, she doesn't spell it out perhaps as clearly as maybe, but that seems to have been her thinking. That yes, this was as serious a case as you can get, which it clearly was, because it was a case of
a senior officer perverting the course of justice.
Absolutely.
Perverting the course of justice by a chief superintendent.
On a murder charge.
On a murder charge. So she obviously thought the 50,000 was the right figure. But who's to say that if the Court of Appeal in Thompson had been asked the question, well, what will be the position if there were three claimants, they wouldn't have said 50,000 each.
I think I've got to accept that as a possibility.
I thought you were submitting that Thompson, properly read, was intended to be the global figure available, however many claimants. Well, it wasn't a case of that kind on its facts. It didn't. Is there a passage you can find in Thompson which extends what it says about £50,000 to multi-claimant cases?
No, there isn't a passage which extends it, but the court is giving guidance not only for the cases of Miss Thompson and Mr. Sue before it, because much of the guidance that it gives has got no relation at all to their circumstances. They were detained for 4 hours and 1.5 hours.
But once you accept, as I think you do accept, that Thompson is not dealing with multi-claimant cases, where then has the judge gone wrong in principle in taking £50,000, which is the maximum of which Thompson seems to acknowledge? Indeed, with inflation adjustment, it's less.
Yes, because she failed to step back and consider the extent to which the combined basic damages award and aggravated damages awards.
So before you say she failed to step back, are you saying there was an error of principle in her selecting a global figure of £150,000 in a three-claimant case?
Yes,
you are.
I do.
And what's the error of principle?
I say that Thompson and Sue properly read sets the maximum sum for exemplary damages of £50,000, uprated for inflation to £90,000 at the date of the judgment, in all cases.
Multi-claimant or individual?
Yes.
Claimant, even though it doesn't expressly deal with them?
Yes.
If you look at the guidance that's given by the court in Thompson, starting at page 514 at F, the whole of that is expressed in terms of singular plaintiff, the singular plaintiff. The entire analysis is of the singular plaintiff and directions to be given to the jury about guidance. So, with respect, Mr. Beer, I would disagree with your suggestion that there's anything in Thompson from which you can deduce that the position would be the same where there was more than one plaintiff. It's simply saying how much is the maximum you can award in relation to a plaintiff.
Well, if that's the court's view, I will move on to the...
Please don't let us bully you away from...
No, not bullying you.
Okay. I didn't take it
simply making the point that that we asked you about Thompson. I don't think there's anything in Thompson that helps you. That's what I'm saying.
If you're thinking that's not principle, may I suggest this, that in terms of assessing the egregiousness of the misconduct and the call for exemplary punishment, surely the number of people affected by that misconduct is a highly material consideration.
I've accepted that already about 5 minutes ago.
Which strongly tells against Thompson being inclined dealing with that situation, doesn't it?
And there were, in fact, 4 claimants originally, one of whom, there was a settlement with one of them. But
yes.
Yeah.
Yes.
I'm sorry, you've got all this piling in against you, but if your point is
So far.
but if your point is right, it could be quite significant, couldn't it, for other cases? Because you are saying 50,000 inflation adjusted is the benchmark top limit.
Yes.
Right.
And that's why since 1997 there's been no award in any case above £50,000 as uprated over the years.
Well, there has now.
But is there any other case which deals with multiple claimants?
We've looked very hard and not found...
Found a multiple claimant case.
Well, there are multiple claimant cases, but not where one is engaged with the top end of the scale.
No, yeah.
So there are multiple...
It's actually 270,000.
Yes.
For 3 claimants.
Yeah.
But what the error we say the judge made was failing to step back in the judgment and consider the extent to which the combined basic awards of basic damages and aggravated damages, which when aggregated amongst these 3 claimants was very substantial indeed, was sufficient punishment for the Commissioner. The 2 subsidiary points that I'm not going to develop other than refer you to the skeleton argument was that the judge didn't reflect in her reasoning that the claim was brought on the basis of the Commissioner's vicarious liability rather than the actual wrongdoer, Mr. Cook, paying the damages. And didn't address in her reasoning the extent to which the wrongdoing had been the subject of intense official and public scrutiny, which on the authorities is a relevant consideration. You'll see the judge's reasoning on the exemplary damages at paragraphs 12 and 13. So this is for tab 5, paragraphs 12 and 13. And then 48. And 53.
Yes.
So she does refer to the absolute maximum of 50,000 in paragraph 12. So she seems to have had that in mind.
Yes, I mean, I think she's in the territory here of narrating Thompson. If you look back to paragraph 9, there's all of the figures that she's giving there are the non-uprated figures.
Say in the field of damages, it gives rise to certainty just to talk about absolute maximum without leaving any wriggle room for save in a wholly exceptional case is quite striking.
Well, the court didn't do that. They said that the wholly exceptional, to start with, exemplary damages must themselves be in a wholly exceptional case. And then to reach the top end, that must be an exceptional case within that exception.
But even then, not to give yourself any wriggle room at all.
I think that's perhaps reflective, I can't say, of the general dissatisfaction with the whole idea of exemplary damages in the law of England and Wales. You know, over time there has been repeated attempts to abolish them, and maybe this was a control mechanism to limit the unprincipled.
Maybe so, but once you are admitting them as a lawful head of damage, we all know the difficulties if you qualify a statement by saying in the ordinary way, and then people pile in and say, well, I'm not in the ordinary way, but you might have to think about that. Anyway, Thompson says absolute maximum.
It does.
You've got that.
Yes. And what Mr. Lima says in reply is that, firstly, the guideline of Thompson and Sue is only concerned with jury cases, not judge cases. That's paragraph 16 to 18 of his skeleton argument.
Yeah.
He says that judges are to be taken to know the parameters in Thompson and Sue, and therefore the concern about making excessive awards by juries is not as acute or as relevant. And therefore it's open to a judge to make an award in excess of the maximum figure outlined in Thompson and Sue. He accepting that the...
Well, judges have to direct juries on damages in accordance with the law.
Yes.
I mean, it can't be one law for judges, and contrary to public perception, it's not one law for judges and another law for everyone else.
We agree, with respect to Mr. Lima, that the logic of the argument is difficult to follow. Yeah. In particular, it would not, if it was not justified for a judge to direct a jury that they might go outside the maximum figure, it's difficult to see why it's permissible for a judge to do so.
I think that must, speaking for myself, I think that must be right.
Yeah. Yes. The second answer, very quickly, is that the hourly and daily rates and the relationship between the basic award and the aggravated award, and the relationship between the basic and aggravated award on the one hand and the exemplary damages award on the other, has been applied since Thompson and Sue over the last 23 years, not only in jury cases, but also in judge-alone cases. I'll give you the quick references: Barnett, tab 6, Evans, tab 8, Washington, tab 9, Muse, tab 17, MK Algeria, tab 19, and I could continue with a list of all of the other immigration detention cases where the Thompson and Sue principles have been applied by judges alone. The third point is related to that, really. It would lead to a two-tier system developing where juries are constrained by maxima, but judges are not.
Well, it's the same as the first one, really, isn't it?
It is.
Yes?
Mr. Lima's second argument, this is paragraph 19 of his skeleton argument, is that it can't be said that the judge was unaware of the guidance in Thompson because she referred to part of it in her judgment, and that there existed some facts which justified going very substantially outside the Thompson maximum. I should say that all of these arguments from Mr. Lima are premised on the existence of a Thompson maximum in a three-claimant case of £90,000. He's setting out reasons why, in this case, it's permissible to go outside of them. His first reason is it's judge alone. His second reason is there existed some facts in going outside the maximum.
Well, that premise may be incorrect.
No, it does appear, doesn't it? I mean, the judge, having quoted that passage or referred to it in paragraph 12, the absolute maximum is 50, must have considered that was for one claimant, which is why she awarded the max. If you look at her reasoning at 53 rather, this award, she says, exemplary damages require this award to highlight and condemn the egregious and shameful behaviour of a senior and experienced police officer. And she then goes on about that at some length, and it's pretty clear she thought that this was a case for the absolute maximum because of the seriousness of the conduct, or the misconduct. So it comes back to the point that I was putting to you earlier. Unless you can say that Thompson covers multiple claimants, it's a bit difficult to say the judge erred in principle.
I'll have one more go on that, if I may.
But I don't think it's quite right that Mr. Lima's arguments are premised on the basis of £50,000. Because look at paragraph 20 of his skeleton.
Well, I was waiting for my learned friend to get to that. You know, that's the point. You know.
Mm.
Yes, I'm saying the points that he'd made to date, the 2 points that I was dealing so far.
Well, all right, but all I can say is Mr. Lima was certainly on to the point about Thompson being a one-claimant case only.
Yes, You know, I was saying that the point, the two issues that I'd addressed so far, sorry if I didn't make
I'm
that
so
clear.
sorry, okay, my misunderstanding. Right.
I.e., there is a ceiling. It applies in multi-claimant cases, but there were the following reasons to break through the ceiling. This is a judge alone case, and there were some facts that justified it. Can I have one last attempt, please, at the Thompson multi-claimant point? Thompson was decided in 1997, a decade after Riches had been decided. One can see that in the authorities bundle.
Yeah.
Yeah, we'll take it from you.
Yeah.
And the idea of splitting in multi-claimant cases identified in Riches was therefore known to the Court of Appeal in Thompson, Riches having been cited to it.
And cited in argument.
Yeah.
It's not referred to in the judgment.
It's not in the judgment. One can see that from the top of 500, page 500, tab 6. In between the hole punches at letters D and E. The purpose of an award of exemplary damages is obviously to punish the wrongdoer. There was only one act or category of wrongdoing, not to compensate the pool of victims of it.
That's really your core point, isn't it?
It is. And therefore, consequently, the focus in an award of exemplary damages is on the defendant's conduct and not on its effect on a claimant or a number of claimants. But I take the point that the fact that a defendant's conduct affects a larger number of people may make it more serious and therefore more deserving.
But never going.
Correct. And there's no suggestion in
So
any
if
of...
that's a completely outrageous and deliberate action, just by way of theoretical example, by the Secretary of State, causing an individual to be detained, wholly wrongly, for many, many months, attracting exemplary damages, the ceiling for that person would be just the same if that conduct was pursuant to an outrageous and wholly unlawful policy known to be unlawful, which affected 1,000 such immigrants.
Yes, because the elements that one brings into account in awarding exemplary damages take into account the fact that the wrongdoer is very rarely the person who's paying. Yes.
As here.
As here.
As here. And that's a relevant factor.
The fact that there are other mechanisms, disciplinary procedures, criminal proceedings, parliamentary accountability, that address the egregiousness of the conduct. And that money is a very blunt weapon with which to punish a person who, when paying the bill, has in fact done nothing wrong. That's why the Court of Appeal in Thompson put the absolute maximum involving directly...
In a sense, it has no deterrent effect because the person paying doesn't need to be deterred. And the person who's caused all this to happen doesn't have to pick up the bill.
No.
Yes.
So exemplary damages very often, well, sometimes they can work, sometimes in some contexts, companies, it can happen, but in this kind of context.
Yes. I mean, there's a whole separate line of authority and issues over joint tortfeasors.
Absolutely.
Where one pays according to the pecuniosity of the person with least money. Which is why claimants never bring claims against the Chief Officer of Police and the person who's in fact done something wrong. Because they might be an officer late in service with a pension, but not much more.
You get all the list and Romford Ice principles as well.
I'm sorry.
Yeah, well, sorry, I was musing, no matter, I was musing, yes.
Yes, I mean, that's why sometimes the speeches that one hears in these cases, rather frequently, to jury members, that you must send a message to the Commissioner's desk that must arrive with a loud thud to tell her what's gone on here is wrong. It bears no relationship to what's actually going on. If an officer's done something wrong, then disciplinary proceedings, criminal proceedings need to be taken against them.
Right.
In relation
points on your cross appeal?
No, in relation to the no stepping back point, I've made the point already that in the 23 years since 1997, there have been no awards of exemplary damages where the absolute maximum identified in Thompson has been exceeded. And this case therefore stands alone, breaching the ceiling. As to the vicarious liability point, we've said what we need to say in paragraphs 31 and 32 of our skeleton. This, in short, ought to have acted as a significant restriction on the judge.
You agree it's a factor to be borne into account. It's not of itself a knockout blow.
Mr. Johnson put it as a knockout blow, no award at all. But I think in argument, he, looking at the note, he accepted that it was an important factor.
And the judge recognised that it was a relevant factor and took it into account.
Well, I think the high point of that is is 53.
Yep.
I don't think she does there.
I think, no, she does definitely do it. Actually, does do it elsewhere.
She recorded a submission about vicarious liability somewhere else.
She does. Yes.
It'll be between 42 and 45, which is where she... Yeah, it's at 44.
She refers to the argument there, yes.
Yeah.
I don't think she's
somewhere else.
I don't think she... we find evidence of her taking it on board.
Well, she's recorded the submission. She's taken account of it, hasn't she?
Well, but no. The narration of what each side has said is insufficient for this court to conclude that she has actively brought it into account when her reasoning is set out in 53 and 54. So,
was there actually a submission to the judge? Your learned junior will be able to help us, perhaps. Because one notes from 42 and 42, the arguments that Mr. Byrne was arguing for up to 100,000 exemplary damages. For the first two claimants, and Mr. Simlett was arguing for 90,000 for the third claimant. Was there actually an argument raised by Mr. Johnson to the effect that the judge was limited to 50,000 in respect of all of them?
Yes. If you turn up page 109, please.
Yeah. Is this in the skeleton argument?
It is. It's also reflected in the speaking note. I'll find the reference in a moment. So it's paragraph 35 of the skeleton argument.
Yeah, thank you.
Absolute maximum is 90. See Thompson at 517, which is the correct reference.
When Mr. Paragraph 40 is the first two claimants seek a substantial award exemplary damage between 70,000 and 100,000. Was that each?
Well, I've got to say it's not clear. It's not clear. When rereading, I've reread and reread this.
And the written arguments and don't assist on that. And speaking notes.
It's in the bundle.
It's made more obscure by the fact that Mr. Bowen was, I think, representing three claimants
I think it's two.
So, yeah, sorry, two claimants by the time it came to damages.
Paragraph 30 of the skeleton argument at page 99. And
I hadn't studied the speaking note, I'm afraid.
in the speaking note at page 70.
Thanks.
So in answer to my Lord Justice Flaux's point, yes, the maximum point was squarely before the judge.
But at all events, Mr. Baird undoubtedly was going above 90,000.
Yes.
Right?
In relation to whether other official public scrutiny ought to have been brought into account by the judge in setting the exemplary damages award, or we refer to our skeleton argument on this issue, and I don't propose to take up the court's time. That's paragraph 33 to 35.
Paragraph 33 to 35 of,
Yes.
of the...
Our skeleton argument. So this cross appeal involves essentially 2 points. £90,000 was the absolute maximum.
Across the board.
Yes. And in any event, the judge did not engage in the stepping back exercise required by Thompson, and then bring into account the points that have been squarely placed before her. I help the court further, or try to.
That's very good, Mr. Baird. Thank you very much indeed. Now you can respond to the reply, please, first to your appeal, and then respond to what's been said on the cross appeal.
Yeah, I'm conscious of the time, my lord, but also what you'd mentioned earlier. So are you content for me just to go on into what would be a lunch break?
How long do you think it'll be?
I think in total, no more than half an hour, but I think to say it's
as long as that?
Well,
the
difficulty...
you don't need to be as long as that.
No, well, can I just say, my difficulty is, and perhaps I'll get some guidance from your lordships, is obviously I produced a relatively detailed skeleton dealing with the cross appeal.
You did a very good one.
Yeah,
yes.
thank you. Grateful for that. My learned friend has not actually gone into an enormous amount of detail on all of the various heads of his argument. I mean, I could, for example, just say, well, on vicarious liability, I'll refer you to paragraphs, what I said at paragraphs 21 to 22.
If that says what you want to say, then don't say
right. Well, okay. Well, can I try and constrain myself to 15 minutes?
Shall we see if you can conclude your submissions in 15 minutes?
15 minutes.
All right.
So I'll deal with the cross appeal.
Are you happy to sit on during the lunch hour, and then we can hopefully wrap this up? Is that right?
Yeah.
Good.
Okay. So I'll try and do it in
crack
15
on.
minutes. So as I said, you have my skeleton argument on the cross appeal, and there were effectively 4 points made by. Learned friend.
So are you replying first on your own appeal, or are you responding?
Well, I'm in your hands, but I was going to deal with the cross appeal first.
All right, then cross appeal first. Right.
Yeah. Okay. So 4 points were made. First of all, failure to look at the total award of damages, whether that award afforded sufficient punishment. Did it exceed the maximum figure stipulated in Thompson? What about vicarious liability? And what about having proper regards to the extent of public scrutiny that the conduct has attracted? So on the first point, did the judge effectively consider the total award of damages and whether that afforded sufficient punishment? Well, that's dealt with in detail at paragraphs 8 to 13 of my skeleton argument, and I give you various citations from the judgment at paragraph 9, and without turning them up, you've got the summaries of them. So it's paragraph 12, where the judge properly directs herself to avoid double counting in relation to exemplary damages and looks at the guidance in Thompson. Paragraph 44, recording the respondent's submission that exemplary damages would be unnecessarily punitive in light of the large sums the respondent would be to paying costs and awards. Paragraph 48 expressly recognises, this is not just recording submissions, but this is her discussion determination, notes and recognises respondent will have to pay substantial damages and costs, and the award of exemplary damages will be a windfall for the claimants, coming from the public funds not available for expenditure in a public good. Notwithstanding all of those observations, so she's considered, we would contend, the overall circumstances appropriately. She then goes on to justify the award of exemplary damages by virtue of the nature of the case. And I've given you at paragraph 9D, 1, 2 to 3 of the skeleton argument, various references she makes in terms of categorising the case, which we're all aware of, particularly gross breach of public trust, case undoubtedly of public importance, and then finally at 48, adequate punishment and public censure requires separate award of exemplary damages to mark the court's denunciation of DCS Cook's unconstitutional behaviour. Right. And without reading any more of it out, you've then got at paragraph 49 of the judgment, the judge again expressly directs herself to remind herself about the total award that's being made before going on to her final conclusions at paragraph 53. So my submission cannot be any doubt the judge has had regard to aggregating the total awards and justifying exemplary damages in sight of that award. And as I say in the skeleton, if anything, the judge was overly generous to the respondents, given the fact that she also was prepared to take into account the size of the costs that they'd have to pay. And I've set out why we say that's wrong, and I won't go into that in detail now. You have that in writing, and I got that. On the maximum compensation figure in Thompson, learned friend took you through what I had to say about that. The key point is the point of paragraph 20, which is the fact that this is a case relating to 3 individuals, Thompson guideline figure related to police conduct relating to 1 individual. We don't say that there is a direct arithmetical relationship between the number of individuals, but plainly it aggravates it and therefore would justify a higher award. That is, in my submission, the strongest point. Start with the strongest point. 2 subsidiary points are dealt with at 1 and 2, paragraphs 16 to 18, and then paragraph 19. The point, my own friend I think said it's difficult to discern the logic of what was being said at 16 and 17, but that's what comes when you selectively cite what's being said. Paragraph 16 and 17 of the skeleton argument, simply the point that's being made is that what was being said by the Court of Appeal in Thompson was expressed as guidance. Guidance for a judge to give to the jury, and the explanation for that was, and I've set that out at paragraph 16A and B of my skeleton argument, was to assist juries in the difficult task of distinguishing between aggravated and exemplary damages, and to reduce the potential for fluctuation in awards being made and excessive awards. Given that it's guidance, in my submission, where you've got a judge who's fully aware and has the skill to be able to differentiate between aggravated and exemplary damages to avoid double counting, and will have an eye to the other awards that have been made to avoid excessive awards and fluctuation. In my submission, the judge was not bound strictly by the terms of what Thompson set out. And that's the point that's being made at 16 and 17. Yeah. In those circumstances, in my submission, there's no risk of a 2-tier system developing. And at paragraph 19, I'm not going to go into that. I simply indicate why the judge then decided on the facts of the case to come up with the figure that she did. The 2 subsidiary points made by my learned friend are on vicarious liability and then the extent of public scrutiny. I deal with, and I apologise for rushing through this, but I'm keen to get the points across, but at the same time aware of the time. So vicarious liability is dealt with at paragraphs 21 to 22 of the skeleton argument. The Commission's point, as it had been understood, was that the vicarious liability point meant that an award of exemplary damages should not be made. And that has, in my submission, that doesn't stand up on the authorities. Of course, Thompson, paragraph 21, I addressed this. Thompson was fully aware of the vicarious liability argument, but then went on to set out guidelines in relation to the awarding of exemplary damages. So as far as Lord Wolfe was concerned in Thompson, the fact that it was potentially a vicarious liability case didn't mean that exemplary damages should not be awarded against chief constables. And then the point is expressly dealt with in the case of Rowlands, which was the case that I handed out, hadn't been put in the authorities bundle initially, which deals with what the respondent reliance on Manley. Respondent relies on Manley and says, well, Manley says you shouldn't be getting exemplary damages in vicarious liability cases, but that was a nobody comment. No express reasons were given. Rowlands, the Court of Appeal, addresses this issue.
Was Rowlands cited to the judge below?
Yes, I think it's in the speaking note. I can just find that.
Doesn't seem to have been.
No, not on that one. It might be Mr. Simblet's speaking note.
All right. Well, anyway,
yes.
I hadn't familiarised myself with speaking notes.
Yes, it is. Page 125 of the bundle. It's Mr. Simblet's. I think it's described as supplementary outline submission.
Yeah.
Page 125 Rowlands is cited there. So that was before the judge.
Right.
And I've given you the passages, so I won't pull it up now. But in Rowlands, Court of Appeal addresses the point head on, expresses surprise at the failure to award exemplary damages. I've said in Rowlands, but it's in Manley. Expressly rejected an argument. This is paragraphs 46 to 47, that it was not appropriate to award exemplary damages in police cases involving vicarious liability, and concluded on grounds of policy that exemplary damages could be awarded in cases involving vicarious liability. And
I think what Mr. Beer complains about is although the judge referred to the point being made by Mr. Johnson, the judge then didn't, he says, expressly factor it into her reasoning.
Well, there's no justification. Well, the judge makes it clear in her judgment. I took you to the various passages earlier that she's aware of the fact that this award is coming out of the public funds. It means it's not going to be available to be spent by the public, and those kind of considerations. The point that was made at first instance, my understanding, was a threshold point, namely, well, if you've got a vicarious liability case, you shouldn't be making an award. Once it's been accepted that an award of exemplary damages should be made, notwithstanding there is a relationship of vicarious liability, there's nothing on the authorities which suggests, well, you should then temper the size of that award.
Yeah. Right.
Final point is on extent of public scrutiny. Yes. Paragraph 20.
It's as per your skeleton argument.
Yeah, I'm not going to say any more about that. So, Lord, that's what I have to say on the cross appeal. I'm going to deal with the reply on my substantive grounds of appeal in reverse order, dealing with ground to the interest point first. The submissions and the sort of discussion with the court between my learned friend and the court seemed to coalesce around one point towards the end of the submissions, which was, well, what about the fact that the judge has upgraded the levels of damages in previous awards to make them equivalent to the date as before her? So, for example, we had, she remarked upon the fact that the figures in Thompson would roughly have to be doubled to take account of inflation, etc. That kind of thing. And the suggestion appeared to be made, well, we've got double counting here. If she's going to adjust for inflation, are you not then, if you're making an award for interest, effectively giving double recovery to the claimants, the appellant in this instance? In my submission, that contention is wrong in law. Is exactly the point that the House of Lords rejected from Lord Justice Denning's, Lord Denning's judgment in Cookson and Knowles, which we looked at before in the citation in McGregor. And anticipating this point may come up, the case of Pickett and British Rail Engineering is in the bundle, tab 1 of the authorities bundle. And the relevant page is 173 of that authority. And you'll see the sidelinings. So if you go back to 172, you'll see the start under the heading.
The point really is that if you've upgraded for inflation, what you're getting is actually exactly the same as you would have got 4 years ago.
Exactly, but without the opportunity for that money to be invested, etc. And yeah, so that's exact, and it's described as a fallacy.
Scarman, isn't it, between D and E?
Yeah, I can't. I probably can't. I'll allow you just to read that. I'm sure I can't express that any clearer than has been there. It describes it. This is a complete non sequitur, and that, in my submission, is the error in my learned friend's approach, and that's really all I have to say about interest.
Yeah.
Actually, other than this one point, of course, the figures I gave you for 2%, that was just illustrative, and I'm not going to take you to this, but one of in the event that you conclude that interest should be awarded, of course, there is a question as to, well, at what rate do you award that at? And of course, that would be open to discretion of the court. But of assistance in that regard is just if you have a read of the judgment of Carrasco, which is the new case 29A, Court of Appeal case, which talks about the factors that the court should take into account when deciding what interest rate should be reached. Now, I don't urge any particular...
Which case?
Carrasco.
Carrasco
and Johnson, and it's at 29A, and it provides guidance on what factors to take into account and what interest rate you should ultimately come up with. Now, I don't urge a particular interest rate on you. That's a matter for the court, but the 2% I was giving as an illustrative example as to the substantial figures that are involved in this case, given the length of time. So that's all I have to say about interest. Finally, turning on to the quantum award per se. Probably have about 3 points to make. First point is, my learned friend's submission, at the outset of his submissions, was that the immigration detention cases are particularly inapposite as comparatives. Well, that's exactly the point that the appellant seeks to challenge, which is, don't categorise them, look at the facts of the individual cases and see whether they can be provided assistance or not. So that is the crucial point of distinction between the two parties, and the appellant would seek to urge the opposite contention upon the court today. Second point, and I made this point in submissions, but learned friend, Ms. Bowen, QC, came back on it, is as to the criminal discount. Now, the appellant's case is, yes, there should be a discount for prior criminality, but that's only where it relates to a person's experience of incarceration. There's no case law to support the proposition that just because you're a criminal, per se, therefore the amount of damages for distress from loss of liberty should be reduced. And he cited 3 cases in support of the opposite proposition. And I'm not going to take you to them, but I'm just going to give you one line on each. He gave you Barnett, Clark, he said Wilkinson, but it's Wilkinson, I think it's Wilkinson and Barnett. Barnett, Clark and O'Brien. In Barnett, the reduction was made expressly because of the person having had prior experience of detention. So yes, there was criminality, but the reason was because of the prior experience of detention. In Clark, that wasn't in relation to loss of liberty, that was in relation to malicious prosecution, and I accept there can be a discount for criminality in relation to malicious prosecution. Indeed, the judge did that in this case, because of course the person's reputation is not as high if you've got previous convictions in relation to being prosecuted for something. So that's clear, and there's no dispute about that. And finally, O'Brien. But O'Brien and that line of authorities in the statutory compensation scheme context, previous criminality was expressly within the statutory scheme a matter to which the assessor should have regard when determining an award for loss of liberty. So that's all within a different context. So in my submission, there's nothing to support the proposition that criminality per se should be something which reduces the award.
Is there anything to negative that proposition?
Anything against what I'm saying?
No, anything against the proposition that you say isn't supported in any of the authorities.
Well, I would simply say, as a matter of principle, it doesn't make sense. Why? Simply because somebody has got a previous criminal conviction.
No, I understand the point of principle, but I'm just asking whether there are any authorities that support what you're saying.
Oh, I see what you mean. Oh, yeah, in terms of saying expressly, well, it doesn't relate to that. Not that I have to my fingertips or to hand.
All right.
Or that I'm aware of. Right. So I have one, possibly two further points. First point is, learned friends' submissions were on the basis that the judge in the present case had separated the award, that's the point I made on numerous occasions, separated the award of distress from the award of loss of liberty. But it's important, and I'll make the point again, it's important to note that the award for distress, she called it distress, but that was the award for the malicious prosecution and all of the factors which are related to that malicious prosecution. And I referred you to the various passages in the judgment at the outset of my submissions which showed you what she took into account for that element of distress. But that is distinct from the anxiety, distress, in inverted commas, which relates to loss of liberty. So she distinguished the two. So in those circumstances, because she has therefore allowed for, under the loss of liberty award, for distress relating to loss of liberty, as opposed to distress relating to the prosecution, there is no conceptual problem in looking at the immigration detention awards, which, it's quite right, don't separate out distress and loss of liberty, because the distress arising from loss of liberty is, in the present case, all under the loss of liberty head, as it is in immigration detention cases. So that, in my submission, is not as substantive and a systemic reason to have concerns about the applicability of the immigration detention cases. And my one final point is on, my own friend described it as a jury point, on the Torrance case, which was Mr. Justice J's recent decision that we looked at towards the end of my own friend's submissions. 586 days of detention, and he awarded £65,000 in damages. And he said, well, that's consistent with the present case. Well, of course it's consistent with the present case, because Mr. Justice J
followed it. Well, had regard to it.
Well, it had regard to it. If, of course, you form the conclusion there is something wrong in principle with the award in the present case, then that would follow that Mr. Justice J's approach is wrong. So it doesn't really take us anywhere in my submission. So, my lords, my lady, unless I can assist you further, those are my submissions.
Thank you very much, Mr. Do you wish to reply on your cross appeal?
No, thank you.
Right, well, we'll take time to consider our judgments, but thank all of you for excellent arguments, and thank you very much also for getting on with it. It doesn't always happen in this court, so it's rather good when it does happen. But we would like to consider, we'll send out our judgments in due course in the usual way, typographical and corrections only, not to re-argue, and hopefully you can agree any consequential matters resulting, and no need for anyone to attend the actual handing down. Any other points at this stage?
Lord Mayor.